With regard to item number 54, this is CRP IO, my lord. Your lordship directed to list this matter for admission, but it has come up for order, my lord. May I pray this matter should be taken up at 2 p.m., my lord, to dispose of this. Both the sides are present today. 54.
For the respondent, my lord.
No, we'll take it up. Don't worry. Take it up.
Oh, obliged.
May it please your lordship. Lordship, a humble request before your lordship in regard to item number 6, lordship. Lordship, if at all this matter gets called up in the first lordship, can it be taken up at 2, lordship? Because lordship, I am afraid it may get clash with some matters in court number 1, lordship. That's why. If at all it gets called, lordship, item number 6.
What is the matter about?
It's CRP IO, lordship.
For
Against a order passed in the miss appeal, rejecting the mandatory injunctions.
so
Lordship, I will be doing the case, but if it gets called up with the first up, lordship, can it be taken up at 2, lordship, second call at 2, lordship? Because I'm afraid it may get clashed by some other items in court number 1, lordship.
don't worry, we take it out as the first item today.
But item number 2, lordship, there.
We'll see when the matter issues. Next.
On the
May I please, lordship? One substitution matter relating to IA may be taken up on 18th or 19th for order, lordship.
Why?
The applicant has expired in the meantime. 2 months ago, I have filed one application that is not yet listed, lordship. 18th or 19th. 18 is Sunday, 19th or 20th for order, substitution
Okay, 20 June.
on 22.
June.
22 June.
You said June.
No, not June, no, this
No.
one, lordship. On 19th or 20th.
Let's have it on 26th of May.
26th of May.
May I please, your lordship. Lordship, I beg to mention a CRPIO for listing admission column. Matter may be listed next week.
Okay. 26th.
May it please your lordship, I beg to mention one RSA. We have filed one IA for implement of party as some respondents were left. So for the in orders column,
Okay.
Okay, 28.
obliged.
I beg to mention, my lord, those two RSAs, my lord, which were parted before your lordship. Lordship had directed them to be listed on 13th of May, yesterday, my lord, top of the list. They were not listed yesterday, nor today, nor in tomorrow's list. Never, it may be listed on any day convenient to your lordship, since there are two parted matters. Otherwise, my lord,
Have you seen the order?
no, that order is not uploaded. That is what the registry has told me. I've checked in the court system.
How is it possible?
It's of the order is,
Oh, may have been these two order was passed subsequently.
yes.
Check it out, give the number to
I
him.
will give-
We'll see when I can't
Good.
give you any date on that. I'll see him.
Okay, I'll give-
Just check it out.
May please, your lordship. Lordship, I beg to mention that listing a matrimonial matter on next week, lordship. Next week. is on-
Why?
Lordship, on last occasion, your lordship adjourned on the request of, on behalf of May, lordship, for listing for 2 weeks, but not listed, lordship. That is why I'm waiting for the next week, lordship.
When I don't fix a date means the person concerned was not interested.
Oh, no, sorry, lordship.
No, obviously, otherwise I fix all cases with a date. I fix a date when there is no person who is not interested.
During that time,
Then-
on last
So
occasion,
no, that will go before the registry. I'm not going to give these type of things.
on next week, lordship, one condition I will have your.
No, sorry. When I don't fix a date means the party is not interested.
May it please, your lordship. Lordship, I pray for listing of a motion matter, lordship. Civil revision petition. Before the tribunal or trial court, my lord, matter is fixed on 17th. Can we have it on 16th, my lord? Okay.
May it please your lordship, I would like to mention listing of one IA on 19th, your lordship.
Why?
Your lordship, because we are the respondent here, but we have not got the copy of the petition at all.
So go and ask the council out there. You know who is the council? Ask him.
Lordship,
Then
your lordship, and we would like to know if the matter comes soon, then it will be better for us to proceed.
Okay, 28 May.
May please the Lordship. Lordship, I beg for listing of an item, my lord, CRPIO, my lord. There is an urgency because an injunction is also there, my lord. My lord, on Friday, my lord,
Motion?
motion.
This lordship, they are for listing a MSC appeal, lordship, next week, lordship, if possible,
Or why?
for orders. to-
Why?
Lordship, thing is that this appeal has been filed on in the year 2021. Since that this matter is pending, lordship. We have not received any single penny, lordship. I'm for
Was
a
there
appeal.
any order passed for depositing? Then
We have challenged that order.
is there a stay?
No, lordship.
Then go before the executing court. I can't do anything.
It's pending for listing, lordship. For listing.
Why?
Lordship, thing is that this matter is pending since.
I'll only pass an order that listed for hearing. It's already fixed for hearing. And there is in bold letters written mention for listing of matter
No,
for
there is
hearing,
no-
not.
It's pending for
But
order.
if it is listed, it is already fixed for hearing, then have you looked into it? Is it fixed for hearing? Then what is it fixed for?
Fix for lots of things that service has not been completed. We have taken a step, lordship. So this.
You are the appellant.
Yes, lordship.
You have taken steps.
Lordship.
Then why do you want?
Lordship, thing is that they have not appeared yet. So I appear for listing, lordship.
Why?
We have taken the step, they have not.
You are
appeared.
an insurance company.
I'm for the claimant, lordship.
So you are asking for enhancement? Or your appeal was dismissed, claim petition was dismissed?
Dismissed, lordship. Dismissed, lordship.
It was dismissed. So the service is not complete.
Completed, lordship.
Service
It's
is
awaited,
completed.
lordship.
Huh?
It's awaited.
Then awaited means why? Why is it awaited? How can I then, what is the help you are going to get then?
It's list, lordship.
You file an application for taking substituted steps, then only anything can happen. File that application.
May I please your Lordship? I beg to make this one highest Lordship, second
For
hearing. Much of. May I please your Lordship? Lordship, I beg to mention item number 27, Lordship. Lordship, may I allow to withdraw this petition, Lordship.
there's a stay.
No, Lordship.
Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, submits that he has instructions. What's your name?
Is there a
Mr. PJ submits that he has instructions to withdraw the instant petition. Accordingly, the instant transfer petition stands dismissed on withdrawal. Interim orders, if any, stands vacated.
Obliged.
এবার চাই লব হা interim order কি আছে আৰু যদি আছে তেতিয়ালে we have to fix a date for appearance.
Top of the list, item 1.
Yes, what is this? Every day this matter is coming.
Lordship, that I'm passed off for the time being.
Absolutely no.
My senior litigation is court number 1.
I can't help it.
Lord, the plaintiff, they filed a suit for partition. So along with that suit,
What are you challenging?
Lord, we have sought partition of a ancestor of a
What are you challenging?
challenging with that injunction order.
Where is that? Page?
Lordship is taking up the appeal, my lord, FAO.
I'm taking up the FAO.
Yes, FAO, your lordship will come.
Where is that?
1889, my lord.
Then
Now, this suit property, my lord, the defendant, they were trying to dispose it of.
Then
So they were
what
trying
has happened in the injunction proceedings?
injunction for this order we have challenged before this honorable court, there was a direction not to create any third party interest, my lord. The 1427. my lord.
Now, what has happened to the injunction proceedings?
Injunction proceedings, my lord, this that has been stayed, my lord. So
In 1427, my lord, along with this FAO, we have filed an
Where is the order of stay?
order dated
Huh? Where is the order for stay?
1427, my lord. Stay
14?
means, injunction order is there, my lord, that in 1427, my lord, 26/5/23, my lord.
Yes.
It is directed that no third party right shall be created in respect of the suit property. my lord.
Then go there. Let him go there. Go there, fight it out. I'll ask, have you filed your written objection there? You have filed there?
We have, main title suit for lordship, issue has been claimed, lordship.
I'm not on that. Have you filed your written objection to the injunction application? The council, has he filed it or not?
My lord, as per my instruction, he has not filed it.
Okay, you file it within 15 days. The court shall dispose it of within 30 days. I'm disposing of this matter. Unnecessary, this type of matters should not remain. And what is your ground? Tell me,
My lord,
why do you want that? Why should this court exercise these extraordinary powers when the court have issued notice?
My lord, our
What third party rights?
contention is that, my lord, it is a, my lord, property, family property, my lord. Now, the respondent number 1 and 2, they are going to dispose of that property.
No, then 52 will come in.
So that is why 52, my lord, in order
No
to avoid
case.
multiplicity of proceedings, my lord.
No case.
So therefore, my lord, we said that at least no, our prayer was that
No
status
case.
quo be
The court
maintained.
have
or no-
duly, I have perused the decisions. On
Yes.
perusal, I find that it pertains to matter of so and so, as considered by the learned counsel for the petitioner, the factors of their relied are completely
My lord, the
different
fact
from
may
the
be
present,
different,
which
my
is the
lord, the
suit for
proposition of
partition.
law which follows from
I
this
take
judgment.
reverential consideration of the well-established of the grant of injunction of the Supreme Court. On hearing the parties and perusal, it transpired the parties are family members and co-sharers of the property. That being the way before passing an interim order, I deem it here. The order was passed on 17/5 and next date was fixed on so and so. What is your thing that they are transferring, going to transfer? Show me.
Lordship in-
What is the urgency shown? That they are negotiating to develop, developing, creating third-party interest over the suit property and or change the nature of the area. And when did you file the suit?
On 15/5/23, my lord.
Huh?
15/5/23.
And you came to know on 22/2 that they are trying to sell. Then where is the question of injunction?
No, my lord.
Kindly come to page 82.
On 22, when the.
So if you have come to know about this,
Yes,
why
ma'am.
did you file it on 15/5? The suit?
It is a dispute between the, my lord.
So
family members.
what? So
Family
what?
members. So when we came to
We
know.
are
my
not
lord,
going to
so
interfere with this type
when
of.
we came to know, my lord, that this,
Therefore-
brother is trying to
No, no, nothing doing.
My lord, if third party interest.
So
right is
what?
created-
52 will come in.
My lord, it will again lead to multiplicity.
So what?
proceedings, my
No
lord.
worry. Your suit has already been filed.
The suit has been filed, my lord, so it will lead to multiplicity. of
So what?
proceedings in sub-
Multiplicity, let
So
it
to
be.
avoid, my lord.
They will be
multiplicity-
bound. They will be bound by the decree.
They are bound by the decree, my lord, then it will again lead to, my lord, suppose this third party right is created, my lord. Now the person.
Go
to
before that. We
Yeah.
are concerned, Mr. Das, we are only concerned with 17/5 to 2023. I can only pass an order to that effect. They will file their objection within 15 days and thereupon the court will decide that application. That's all.
Third party right should be created, my lord.
No, nothing doing.
Till, my lord, that.
Absolutely no.
Suppose, my lord.
Because we are concerned with only this order, because you filed this suit only on 15/5. When you said the cause of action happened to you on 22/2, then what on earth, was there any other mention out there?
My lord,
Then,
as it was a family property, we, my lord, when we came to know the sister, they tried to settle it out, my lord, amicably. But when nothing happened, my lord, then ultimately finding no other options, my lord, they had approached, my lord. Let it go before the court and feel that, my lord, some protection, my lord.
A Das, the learned counsel appearing on behalf of the petitioner. Mr. So appears on behalf of the respondent. Full stop. This is an appeal filed under Order 43, Rule 1R, read with Section 104 of the Code of Civil Procedure 1908, challenging an order dated 17/5/2023, passed in Mizze case number 491/2023, arising out of title suit number 293 of 2023. Full stop. The order, impugned order dated 17/5/2023, the learned trial court, instead of exercising its powers by waiving the notice under Order 39, Rule 3, deemed it appropriate to issue notice upon the respondents before passing any ex parte ad interim injunction order. Full stop. The petitioner herein, who were the plaintiffs in the suit, petitioners herein, who were the plaintiffs in the suit, have approached this court that in the meantime, if any third party rights are being created, it would lead to multiplicity of proceedings, and as such, sought interference with the order dated 17/5/2023, passed in Mizze case number 491/2023. Full stop. This court have duly perused the application filed seeking injunction, which was registered and numbered as Mizze case number 491/2023. From a perusal of the said application, and more particularly at paragraph number 9, it is seen that the cause of action, it is seen that there is an allegation made that on 22/2/2023, the petitioners have come to learn, the appellants herein had come to learn that the respondents herein were negotiating for selling, developing, creating third-party interest over the suit property and or change the nature and character of the suit property. However, the suit was filed on 15/5/2023. Full stop. If the appellants could have waited for 2 months, could have waited for nearly 3 months for the purpose of preferring the suit, filing the suit and seeking an injunction, this court finds no ground, finds no error in exercise of the jurisdiction by the learned trial court in issuance of a notice before grant of an ad interim ex parte injunction. Full stop. This court further additionally, this court also is of the opinion that the jurisdiction exercised by the appellate court against an order by which the learned trial court had, in its exercise of its equitable jurisdiction, decided not to grant an ad interim ex parte injunction, being limited, the question of interference with the order dated 17/5/2023, or for that matter, granting an injunction by this court at this stage did not arise. Full stop. This court also inquired with the learned counsel appearing on behalf of the respondents, who are the defendants in the suit, as to whether they had filed their written objection as well as their written statement in the suit. You have filed? It has been brought to the attention of this court that written objection has been filed before the learned trial court in the injunction application, as well as also in, as well as The written statement has also been filed in title suit number 293/2023. Pusto. Come here, come here. Come here. We can't hear you.
Statement, that injunction in the, injunction, objection in the injunction is concerned, I'm not sure.
You are?
That has not been filed, the objection in the injunction.
Okay.
Written statement.
Had inquired with the learned counsel for the respondent as to whether any written objection has been filed to their injunction application before the learned trial court. The learned counsel, Mr. B.D. Goswami, submitted that no such objection has been filed, taking into account that the injunction proceedings are pending before this court.
So, exactly.
Full stop. He further submitted that the written statement have already been filed in the suit and issues have also been formulated, framed. Full stop. Taking into account that the said injunction application objection to the written injunction applications have not been filed, comma, this court grants 15 days time to the petitioners, respondents herein who are the opposite party, who are the defendants oblique the opposite parties in the injunction proceedings before the learned trial court to file their injunction. That is, to file their the written objection before the learned trial court on or before 2nd of June 2025. Full stop. This court further directs the learned trial court to dispose of the said injunction application within, at the earliest and preferably on or before 27th of June 2025. Full stop. Full stop. Are you changing? Are you going to sell off?
No,
Mr.
no question.
Mr. B.D. Goswami, the learned counsel appearing on behalf of the respondent, submits that there is no attempt on the part of the respondents herein to create any third-party rights in respect to the suit property. Full stop. Taking into account the said, comma, this court observes that till the disposal of the said injunction application, comma, there shall not be any creation of any third-party rights over the suit property. Full stop.
I'm deeply aware.
In any case, but because of the tendency of the litigation, they will not get the.
This court further observes that this court further finds it relevant to observe and clarify that the directions given to the respondents herein not to create any third-party rights till the disposal of the said injunction application should not be construed by the learned trial court to the effect that should not be construed by the learned trial court, or no, should not influence the learned trial court while deciding the injunction application. This type of matters are absolutely, I submit.
In any case, because of the tendency of the litigation, they will not get that 50, that certificate is necessary, madam. In any case, it is not possible, madam, to transfer.
For motion item 2.
We impose a cost of 10,000. This court further taking into account that the instant application has been filed, instant appeal has been filed, and gross abuse imposes a cost of rupees 10,000 upon the appellants, which shall be deposited before the learned trial court on the next date.
Genuinely pursuing this case.
Hey, last to সেইখিনি গুচাই দিয়ক। এইটো যে injunction দিছিলো, এইটো গুচাই দিয়ক। No injunction.
Then Lordship will remove post.
First I've removed it. No injunction.
Then only observation that the trial court while adjudicating in the matter will not get influenced by this order.
Obviously, I have not said anything.
No, that is why, because they may argue before the trial court, my lord, that as this honorable court has not interfered with the injunction application, therefore it is not a fit case. So only an observation that while adjudicating that matter, the trial court will not be influenced by
My
this
right
order.
of argument is my reserve, my lord. I'll take whatever points, my
So
lord.
that is why, my lord.
What I argue
then-
there. my lord, they
Otherwise,
cannot
my lord,
block me.
they may take this is only an observation, my lord, that they will not get influenced by the order while considering that injunction application. my lord.
And how big? You don't transfer anything.
We were not doing, my
Yeah,
lord.
no.
And we cannot do
You
it,
do
my
have
lord,
a
because
till the
it's
next,
not possible.
till the next day. Truck.
I'm deeply.
Much of-
Made to Lord.
Yes, what is this?
My lord, plaintiff's prayer for withdrawal with liberty to file a fresh suit was allowed. The case is like this. The plaintiff, my lord, received around 2 bighas of land from her father. Out of the 2 bighas of land, my lord, she had donated 3 kata 15 lesses of land to the predecessor of the defendants. Now, my lord, they in their plaint, my lord, took a plea that we have mutated our name over the entire 2 bighas of land. So they filed the suit praying for a declaration of right title and also for cancellation of the mutation order. Now we took the plea that, my lord, that entire 2 bighas of land was donated. Now after 9 years, my lord, they have come up with this petition. Now what they want to say, my lord, will kindly see the petition at page number
What was
29.
the stage of the suit?
Evidence, my
Whose evidence?
plaintiff's evidence. Now they want to say that not only the 3 kata 15 lesser, but entire 2 bighas of land was never donated in the name of the defendants, my lord. So, my lord, by this petition, they want to withdraw an admission, my lord.
Huh?
The admission which they had taken in the first plaint, my lord, that only out of 2 bighas, 3 kata 15 lessers of land was donated. Now they want to say that no, no land was donated to the predecessor of the defendant. Courts will kindly see page number 29, para number A.
Why the want of notice under section 80?
So they want to say that from the Jamabandi, they came to know that some school has also got its name mutated over the suit parta. So they had not made that particular school a party. So now they, after 9 years, they now come.
No, why 80?
Because they want to say that it's a government school. That is why section 80 notice ought to have been issued. That's their contention, and after period of 9 years, now it is not even known whether the Jamabandi was with them or not. And another point, at D, we had taken the plea in a written statement that out of the 2 bighas, we had transferred around 1 bigha of land to one Hossein Ali by way of registered deed, and his name was also mutated. That plea was taken in a written statement back in the year 2016. Now, after 9 years, they want to say that no, that person's name, he was not implicated. We had to challenge that deed. That was also not done. So now we come to know. So these things, are not even formal defects, and the learned court below, without taking into consideration, had allowed the petition. Without even discussing whether there are
So
formal
what do I
defects.
do?
My lord,
What do I do? I
notice be
yes,
issued, my lord,
notice I will issue, then
and at least at this stage, my lord, the order may be stayed.
suit has been disposed of.
Yes.
How do I, means the suit? How can I stop or stay a suit which has been disposed of?
No, the order, my lord, the operation of the order. Otherwise,
The
by virtue-
operation of the order, if I stay,
yes.
wouldn't the suit revive?
No, but if they file a new suit, my lord, fresh suit,
So what the order, therefore I am asking you, what order should I pass?
Let the notice be issued and
That
operation.
too obviously I will do,
And
don't worry.
operation
with
of
that.
this order, impugn order, is state, my lord.
If I impugn order, if I stay, the suit revives,
Yes,
then who is going to fight if he is not willing to fight?
but that's what we want, my lord. Let the.
How is it possible? Isn't it the final relief?
Yes,
If I stay this order,
Yes.
isn't it the final relief?
yes.
Then how can I do it? Tell me, give me a good idea. You're an expert civil lawyer. Tell me. You are. Tell me. The moment I saw that order, the
Yes.
only thing which came to my mind is if I stay, the suit will revive, which will
Yes.
amount to a final order without hearing the other side.
So that suit, my lord, can be kept at abeyance, my lord, till this petition is disposed of, my lord.
Huh?
The suit will not proceed, my lord, till this petition.
I will revive the suit. The moment I stay this, it will
Yes.
revive the suit.
Yes,
Then, isn't it your final order?
my lord, that suit is at this stage of evidence, my lord. So
Understood.
if the suit gets revived, my lord,
Then,
my lord,
no, isn't that your final order?
yes.
If I stay this,
Yes.
isn't that would be your final order?
But if your lordship does not stay, they can also, my lord, go on with and file a fresh suit, my lord.
So what order should I pass?
But if that
If
is-
I file a suit,
Yes.
if they file a suit,
Yes,
if I stop him from
Yes.
filing a suit, who will take care of the limitation? Because that list is not before me, the new suit. Who will take care of the limitation? Can he get the benefit from here? Under any of the provision from 4 to 24? No.
14, my lord.
14, he has not filed the suit.
He is
He
yet to
has
file a
not
suit.
filed these proceedings.
Ah.
Then how does he get the benefit under 14?
Suppose, my lord, if the suit is, my lord, if the suit is revived, then if a direction is made, that suit will not proceed till the disposal of this and be kept at abeyance, my lord.
That I can't. And why this 115 business?
Because that was.
Who had filed the petition?
The plaintiffs.
And his petition, if allowed, would lead to disposal of the suit? Very well. So, if you see the proviso, the first proviso to section 115, it says who?
That the High Court shall not under this section vary or reverse any order made or any order deciding any issue in the course of a suit or other proceeding, except where the order, if it had been made in favor of the party applying for revision, would have finally disposed of the suit or other proceedings. Yes.
Isn't it the other way around? So what it should be your petition? 227? I hope. Heard Mr. Esdas. Esdas?
Yes, that's right.
Learned Counsel appearing on behalf of the petitioner. So at the outset, the Learned Counsel submitted that there was an inadvertent error in filing the instant petition under section 115 of the Code of Civil Procedure 1908. Inasmuch as the order which is challenged cannot be revised in view of the provisions or in view of the first proviso to section 115 of the code. The Learned Counsel therefore submitted that the instant proceedings be converted to a proceedings under Article 2 to 7 of the Constitution. Full stop. this court have also perused the impugned order whereby the application was filed by the plaintiff seeking withdrawal of the suit with liberty, which was allowed by the learned trial court. First, considering the above, this court is also of the opinion that the instant proceedings should have been proceedings under Article 2 to 7 of the Constitution. Accordingly, this court converts the instant proceedings from Section 115 of the Code to a proceedings under Article 2 to 7 of the Constitution. First, issue notice making it returnable by 2nd of June. No
We'll take
stay.
Dusty, my lord. We'll take Dusty.
2nd of June. First, steps be taken upon the respondent numbers 1 to 6 by way of registered as usual during the course of the day. First, in addition to that, the petitioner is given the liberty to take steps by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. First, next, the petitioner herein have challenged the order dated 6/12/2024, whereby the application filed under Order 23, Rule 1, bracket 3 of the Code of Civil Procedure by the plaintiff after at the state filed over here of the code was allowed. First, the learned counsel appearing on behalf of the petitioner submits that a perusal of the impugned order would show that there is total non-application of mind by the learned trial court. First, the learned counsel further submits that the grounds on which the application was allowed, comma, would not come within the ambit of a formal defect or a sufficient or any other good cause as mentioned in sub-rule 3 of Rule 1 of Order 23 of the Code. First, he therefore submitted that the instant proceedings be stayed, that the impugned order be stayed till the disposal of the instant petition. First, this court is of the opinion that passing such an order would amount to allowing the instant proceedings without hearing the other side. First, considering the above, this court observes is not inclined to stay the order dated 6/12/2024 passed in title suit number 248/2014. First, be that as it may, this court, however, further observes that if any suit is filed pursuant to the order dated 6/12/2024, pursuant to the impugned order dated 6/12/2024 by the respondents, comma, the same shall be subject to the outcome of the instant petition. This is the best
Yes,
order.
yes.
You should have thought about it.
Highly obliged.
Item 3.
Please, your lordship. Lordship, on the last occasion, the honorable court was pleased to pass an order for furnishing the order dated 5/3 and 26/3. Lordship, the orders we were not being able to receive the order because due to some difficulties. Will take some time for filing the orders. One week time may be given for furnishing the orders.
Let me give you 1 year.
No, lordship.
1 year?
No,
Why?
lordship.
Let the suit be disposed of,
No, lordship.
then we take it up. You don't seem to be in urgency. We'll issue notice, just issue notice. No stay, let the suit proceed. What do you say?
We'll file it on the very next day. Lordship.
What?
We'll file it,
I gave you time on 2.
yes.
Today is what?
days, Lordship, 14, Lordship.
14. So 12 days. Then
There was,
you're not an urgency. Let us hear the other side and pass orders. And the pendency of the instant proceedings shall not stay. Shall not amount to stay of the proceedings. Let it continue.
Lordship, 1 week time may be given, Lordship, will furnish the document.
It seems that the council it seems that the petitioner is not interested in an early resolution for which the additional affidavit have not been filed as per the leave granted on 2/5/2025. List the matter again on 2nd of June 2025.
Item 4.
Yes, what is this?
May I plead your
What
lordship?
are you challenging?
Lordship, interim notice.
Huh?
Lordship,
Writ of AR swearing the quantum of the notice issued by whereby was selected to the office of the peon. Who have been selected?
Lordship, serial number 62.
10 to Iman, the candidates must have minimum qualification of AR, UR 4 and AR. Who are you?
Lordship, I am at serial number 120, Lordship.
So why are you challenging?
Lordship, actually, I have been working since 2020 November, Lordship.
Then
Uh,
as
As Mali, Lordship, in the state establishment, Lordship.
then
And but when the selection list was published, but my experience was not counted, Lordship, and accordingly I was deprived. And in the entire selection list, some person who had got lesser mark, they were selected,
so these people have got it.
Lordship.
What is your name? Diplu Ali.
Diplu Ali, Lordship.
So you got some 18 marks.
18 marks, Lordship.
Then
Lordship, kindly have a look at advertisement at page 15 NXRB, Lordship.
Huh?
Page 15 NXRB, Lordship.
mode of there shall be a vivavose carrying 30 marks.
Lordship.
Nature of the work, so and so. So,
Lordship, kindly have a look at nature of the works, Lordship. May I
cleaning
read,
the
Lordship?
office.
Cleaning the office, port equipment, furniture, etc. Number 2, operating the generator, water pump, etc. if necessary. Ensuring switching of all fans, lights, and other electric equipments after the office hours of the particular section of office to which he or she is attached, or any other duties assigned to him, her, from time to time. Lordship. Lordship, for a moment, kindly have a look at page 14, Lordship. The certificate issued by the office of
Page?
the 14, 1/4, Lordship. This is the certificate issued by the office of the chief
Oh,
judicial,
your contractual basis. What right you have?
Lordship. But the candidate, those who are selected, they have not any experience. Moreover,
Where is the question of experience necessary?
Lordship, kindly have a moment, see, Lordship,
Who is your senior?
educational qualification.
Who is your senior? Ask him, because I'm going to dismiss. Ask him to come. Yes. What is this? Where is it? You have not read it.
My lord.
Okay, if you want to get the dismissal in your hands, you do it. If you want to put the blame on your senior, then that is why I asked. Otherwise, if you are more accustomed with the facts, you do it. But your petition is going to get dismissed.
My lord, here, my lord, kindly have a look at page 43, my lord. A representation, my lord. Similar elaborate representation was submitted by the petitioner, my lord. My lord, here their basic allegations, my lord, that the candidates, my lord, who obtained higher mark, my lord, they were not selected, but candidates who obtained lesser mark, my lord, they were selected, my lord. It is also
What?
their grievance, my lord.
You got 18 marks.
My lord.
Then
I
I'm lawyer, my lord. I have no problem. I'm lowest, my lord.
Then
But the candidate who is
I'm not
selected-
concerned with others. Let the other person come who is hired. Get hold of that person. I'm dismissing. Withdraw, dismiss, which one? Your contract. Dismiss contractual job goals.
my lord.
Which one?
Take that thing.
Withdraw. Mr. S. Hawk, the learned counsel appearing on behalf of the petitioner submits that the petitioner would be well advised to withdraw the instant petition. Taking into account the above, the instant petition stands clear on withdrawal.
Right.
None appears on behalf of the Guwahati High Court.
Supplementary item 49.
Please, your lordship. The last occasion, we were directed to get the copies of the depositions as well as the order sheets. However, we could not procure that.
You could not get. It seems that the various opportunities have been given to the petitioner. But it seems that by an order dated 5/5/2025, 6/5/2025, the petitioners were asked to place before this court the order sheet pursuant to the impugned order. Full-stop. Mr. S. Dutta, the learned advocate appearing on behalf of the petitioner, submits that the order sheet could not be obtained. Taking into account the above, list the matter on 2nd of June. Full-stop. Pendency of the instant petition shall not be a bar on the part of the learned trial court to proceed with the disposal of the suit.
50.
Lordship, heard the matter
Ah.
last week, Lordship. I pray only some accommodation. Mr.
Why?
Mantha is on
That
late
they
in
were
court-
to dispose or
Yes,
dismiss your
he's
petition.
in court number 1, Lordship, he is coming, Lordship. After
Okay,
some-
let him come with his legs.
Okay,
No, look, it was dismissed.
okay.
51.
Yes, what is this?
My lord, we have filed application for bringing original documents.
Huh?
The suit was for my eviction from the premises. And our plea is that we have actually entered into agreement to purchase the land with the original owner. There was
No,
agreement-
what was the application you are challenging? Which order?
My lord, the order, if you know this page number, my lord, page number
44.
44,
What is the order?
my lord. The order is that my petition has
To
been rejected.
accept the
my lord.
original documents filed as document in the list on so and so.
My lord. The operating part,
Stated the suit was filed for recovery of possession and the eviction of the defendants for recovery of remand. The defendants filed a written statement from counterclaim and filed some copies that is one so and so, so and so, so and so.
operating part starts from page 54, my lord.
Plaintiff side file of section raising of the contention that is complaint.
Page
Then-
54, para 12, operating part starts.
Huh?
The operating part of the order starts from page number 54, para 13.
They give you- So you did not deduce evidence.
Yes, my lord, because of that non-availability of that document. perhaps.
No. You did not deduce evidence.
My lord,
And now you want to bring those two.
my lord.
Means you want the review of the order.
My lord,
Actually,
my
in
lord,
effect, it is a
my lord,
review of the
that
order
adjournment was rejected.
dated 34/2022.
That was adjournment petition was rejected, not review.
So you actually want, because when the court, the next stage is to the stage of arguments. You are the defendant. The next stage was the stage of arguments. So therefore, on 34/2022, your prayer for adjournment for adducing additional defendant evidence was rejected. Now thereupon, you filed this application at the stage of arguments when the final hearing was over, that you want to adduce evidence.
My lord,
Long
bring
and
that-
short, this is it.
To bring that, actually, those, there are some lapses on the part. I don't say that there is not lapses. There are some technical lapses, my lord.
I think,
my lord,
I
think-
only think the Supreme Court can help you under 142. I can't.
My lord,
Chalo.
only one thing may kindly wish that those are the most relevant documents.
So what?
Without those documents, my lord, even
You take that ground in your appeal, which you are going to file if it goes
Order-
against you.
order 41 to 27.
Take that ground there. Don't gum up. If I dismiss it, you cannot. This is the only way. I'm telling you, if I dismiss it, your order 41 rule 27 goes for a 6. You can't take that ground of or you were debarred from taking under 105. All these grounds are stopped because I'm going to hold it that what you are trying to do is actually an attempt being made to review the order of 34/2022, whereby your evidence was closed, which will go against you. Which one?
That is actually, I must say that they have not filed a proper application. They did not file the proper application. The application should have been in some other way. That is correct. So your lordship, if your lordship,
Which one do you want now? Tell me.
your lordship may exercise that power to,
Huh?
in that way also. In that way also, for the insufficiency that can be seen.
No, absolutely no. That too after 2 years. Dismissed. Heard Mr. S. Sharma, the learned counsel appearing on behalf, S.J. Sharma, the learned counsel appearing on behalf of the petitioner. Full stop. This is the jurisdiction under Article 2 to 7 of, Mr. Sharma, you withdraw it. And take it as grounds in appeal if it necessary. Because I'm telling you, if I do it, it will hamper you in order 41.
Lordship, can one do 1 minute? Can it come on second up so that I can inform my client that I am doing it for such and such reasons? Otherwise,
No, you will take it up, you inform the client.
yes.
I rise at 12 o'clock, 12:10 I'm coming.
That-
So first
will be
half
better.
only, it is the end of the matter today.
That is,
First
that
half.
is correct. Lord.
But I think you withdraw it.
Yes.
Because if I dismiss it, your order 41 rule 27 is gone.
For admission item 5, part third.
Yes, what has happened? Anything? Where is K. Gogoi?
Look, I'm appealing. I'm appealing this.
Okay, now tell me.
Look, I have.
Is it going in the direction of the petition or not?
What I find, the adoption has to be as per the guideline. The guideline we cannot override. The CWC now, whatever I have seen, the instructions have been come and the application has been given to the CWC, Child Welfare Committee, who is not the competent authority for adoption.
Huh?
Who is not the competent authority. In fact, the application or the matter has been placed before the CWC. CWC is not the competent authority now in respect of adoption of a child.
Who is the competent authority?
Competent authority, what I have after going through the
Mr. Nath,
the records.
I'm telling you,
Huh.
earlier I made Mr. K. Gogoi, that is why I asked him to do it.
Yes,
We want the child should be under, they should be allowed to take the adoption because Otherwise, what are you going to do with the benefits?
Malad, I'd like to clarify. I am not taking this as an adversarial litigation. I am not opposing. In fact, what Lordship has, my colleague has apprised me and what from the orders of the honorable court I have gathered. I am trying to help it out. But kindly, some procedural things are there, the adoption guideline is there. The authority, whoever is at particular place, they cannot also,
I'm not asking them to override,
not,
but don't make it too technical.
no.
That is what I'm saying. My only worry is don't make it technical because you see, the respondent number 7 out here has no objection in the child being taken up by the petitioners herein. Listen. So therefore, the petitioners and the child, we are concerned with the child. Who for the welfare of the child. Now, are you taking good care of the child? Where?
Child is at a specialized adoption agency, Matri Mandir, called Matri Mandir. Child
Why?
is there. This is the specialized adoption agency under the guidelines.
Understood. Why?
Because.
What are the benefits you are going to give it to the child?
But until or unless the child is given an adoption as per the norms.
No,
the
why you
child-
are delaying it?
No,
This matter is going on from 2024.
I have seen for last 1 year, for last 1 year, it's going on. What my submission would be. Kindly see, the child is now.
Who is the official? Mr. Nath, I'm not getting good vibes from you, what you are submitting. Who is the official? We'll ask him to come.
Kindly.
Bring this.
Kindly
Now ask the chairman of Child Welfare Committee to come.
Kindly-
Who is there? Who is the authority?
I'm pressing it.
Who
Kindly
is
give me
the
one
authority, Mr. Nath? Who is the authority?
minute. See, kindly give me 1 minute.
Yes, tell me.
I'm just placing the guideline. The Kara and the Sara, they are the authority part. The application petitioner has, in the additional affidavit, the petitioner has brought before the honorable court, the application filed before the Kara. Central, the adoption resource agency is the Kara, it is the central level agency. They have an agency at state level, that is Sara, the state adoption resource agency. Sara, through their district, the wing, that is the district child protection unit, they used to make an assessment. Ultimately, while processing their application, some difficulty was found. And that difficulty is they have filed 2 applications. One application, they claim that they are near relative of that particular child. That application has some difficulty that was already apprised to them. I have seen under regulation 63, there is a provision for relaxation of the norms. And the relaxation, it is only for the relaxation committee, the standing committee of the Kara, they have the power, not the state child protection authority. Kindly have a look at the guideline.
I'm not on that, but tell me why. What is the difficulty now?
There is a concept of family. If they are claiming that I am relative, then a concept is there. They doesn't come within that. In the affidavit, they said from the matriarchal, from the family tree they have admitted in their affidavit itself, they have admitted that they could not establish the norms which is prescribed by this guideline. But they said that from the mother's side, they are related, they are cousins, but that is not permissible under this guideline.
What is the, how far is your cousin's goes?
Kindly see their additional affidavit, how they have explained.
Page? Page?
Page 77.
Yes.
This is a part of their affidavit. They said that the paragraph number 3 and 4, Pallavi Mandal, this is the mother of the child, is the permanent resident of so and so, that the mother of Pallavi Mandal, namely Manju Mandal, and my mother, namely Rajeshwari Biswas, are cousin sisters of Srimati Manju Mandal, is the daughter of aunties, Moses of the
mother of Rajeshwari Biswas. As such, Pallavi Mandal is my near relative. As both are under maternal relationship, so family tree is different from each other. So family tree, that family tree, which is matlab, as per the guideline.
Let us see the guideline, what is it?
I'm making submissions that.
Mr. Nath, I am not impressed with your submissions. I'm making it very clear. Try to be helpful to the court. Don't take it away. Which you are mentioning?
matlab,
Don't worry, I'll take care of it. Which one you are mentioning?
The last flag, my lord, the last flag,
You don't know which is it? Family tree?
the relative adoption is defined there.
Inter-country relative adoption.
Inter-country, there is a relative adoption is there.
Where? Huh? Which one?
After that. Matlab, towards the end, there is a,
You have placing before this court, this one you don't know. So it,
real food. The the requirement for relative, my lord, and kindly see now after examination of their documents, page number 75 is the report of the authority. What the difficulty they have.
affidavit by prospective adopter in support of the financial as provided under adoption regulation 202. Consent of the biological for the in-country relative adoption as per year. The consent is there.
Consent is consent.
So affidavit by the prospective adopter in terms in support of the relationship.
Yes.
Financial and social status as provided in share. Where is that?
Lord,
Where is that affidavit?
status report I'm indicating, page number 75. This is again an
No,
additional.
no, we'll look into it later on.
Oh.
Yes. In 24. That I am. Now tell me what is it? What is wrong?
Lord, the observation is page number 75 is the report, status report.
Yes. What is 77? What is wrong with it?
They said from the maternal relationship, they said that they are related by maternal, my lord. There is no family tree. Family tree is different. It is their admission at page number 77. And the report kindly come to page number 75, just before that, my lord. Family tree is different from each other.
that the child proposed to be adopted is a family tree is where?
Page number 77 of their affidavit.
No, no,
they
that
said.
is okay. Where is it here in the regulation
Well,
where that it is required that there should be a family tree?
Status report kindly see on the page number 77 in the same affidavit. Lordship.
No, no, this is okay, but where is it here? That here it says that the child proposed to be adopted is my so-and-so which fulfills the relation criteria as per so-and-so. That is it required?
Relation criteria is given.
Yes, because you see another affidavit given by another one.
Page number 75 is the report.
Then,
They said the relationship of the prospective adopted parents to the relative child family tree as per adoption regulation 22 is not established. That is what they have found.
no, but where does it say that there is a requirement of a family tree?
Because they have to show the relationship. Matlab,
Who has said that? Does the regulation say about a family tree?
yes, Matlab, as
Where?
per the regulation.
Show me that.
Sorry, Matlab, I have only one copy. Take the other. In fact, in the format itself, Matlab, they have to indicate.
Because the affidavit, the form 24.
Yes.
Does not say anything about a family tree. Form 24, which is there in the back, does not say anything about the family tree.
Just a minute. 54:4. I'm coming.
Now kindly come to page 82, which is there in form 24.
Eighty-two. 82.
This is in form 24.
Yes, Matlab.
Exactly. Where do you bring in the family tree business?
Matlab,
If it is not there in the regulation, who is asking you to say that? Let us have this person meet them and talk. As I am not getting the assistance properly from you, let us hear him.
Matlab, the
Well, let us hear him first. Where is that person concerned who has given this
Matlab,
letter?
para number 2 kindly see, Matlab.
Para number 2 does not say anything.
So para number 2 of page 82, they said that the child proposed to be adopted is my nephew
Huh.
and fulfills the relationship.
So that is the
criteria
format.
as provided in section 2, subsection, section 252
Huh.
of Juvenile Justice Act. Matlab.
Hmm. Yes, Mr. Sahu, what do you say? Madam? Ask him to appear. Yes. You come this way. Ask Mr. Sahu to appear. Yes, Mr. Sahu.
In my humble submission, the child doesn't comes in the purview of the juvenile justice act.
Yeah.
Because the act provides two kinds of child. One, a child in need of protection, and that was not defined in the act itself. And if we go through that, and their affidavit mainly, the child doesn't fall under that category. Because in their affidavit, they have said they pick up the child only because owing to some invalid adoption treaty. That was the ground one, my lord. If that be so, my lord, they will be advised The parents may be advised to execute proper deed.
That's all.
That's all, my lord.
This doesn't go there. This court does not find any good intention of these respondents.
Well, in the first affidavit itself, we have indicated what is the detailed procedure. Well, and
Relation to a child for the purpose of adoption under the act means paternal uncle or what is the definition of a maternal uncle?
Definition is at 52, that relative only.
No, no, it's okay. What is the definition of maternal uncle or aunt? Or is it this social service people will define it without the regulation?
six, for interpretation and for relaxation, it is the Kara, they have the.
I'm not on that. Is it defined anywhere who is a maternal aunt?
I have not seen yet.
Then why you are creating that unnecessary difficulty?
Well, even then the Kara is the authority, the final authority, they have to accept.
Why they are not doing it?
Kara, well, I have not seen in the record that the Kara has been, well, has been asked. The Kara is
No,
not
why
there.
the Kara has not been asked? They have duly filed the application. What has happened? Why they are sitting over it?
As per the, well, the records which are available with me before us.
Or ask the person who is more responsible, who knows about the facts, to come before the court and appear. Not you.
The state, from the state authority, I have to get the information because as of today, on the basis of the information,
Let us have the chairman of the child welfare. He has written the letter earlier.
chairman, child welfare is not the authority.
He has
He-
written,
he-
he has
he-
been
he-
giving instructions before the court earlier.
Party here. He is made a party.
He has written instructions. Are you aware of the records, Mr. Nath?
See, I have
Then this particular document has been marked with the letter X by this court, meaning thereby that this chairman has corresponded before this court on certain instructions. So let the chairman be present before this court, will ask you.
definitely-
I am not getting any help from you as you are not aware of the facts properly.
Well, I have-
So let us have the chairman.
kindly-
I am not concerned.
kindly inform me.
Mr. Nath, I am not looking into it nicely.
Well, kindly,
It appears that the change of the council now have resulted in a change of the stand by the respondent authorities.
taking my chance,
I'm absolutely,
just indicating where is the difficulty. Well,
where is
I'm
the
not-
difficulty
I'm
means,
not
you see,
opposing.
the first and foremost, no, Mr. Nath, you have to understand one thing. This child was with these parents. There's nothing wrong with these parents. They have nothing else to do out there. Yes, they have not properly done it, for which you should have asked them to properly apply for that and take it. Why on earth have you taken the child? And what is the benefit you are getting from the keeping the child?
Statutory authority, they have,
And why does it take
The
for
way-
more than a year for you to settle out this? We are concerned about the welfare of the child. And this court does not find that the authority is doing the needful in that regard.
my humble submission.
There is nothing out there.
Well, the way in which this child was adopted is not proper. It is not proper. It was not proper.
Understood.
It was-
So what are you going to do? You are going to snatch away the child. A child who is how much? Now 2 years?
Now 2 years.
Then
Now 2
you are going to snatch away the child and keep it somewhere else?
Well,
Do you know what is how the child has been with these parents out there from at the time of the birth? Their mother has no problem. Mother has said that yes, she is a victim of rape. And this is the status of what is the social welfare department is doing. Don't you have any better things to do?
But the department, department has, is not opposing that. In fact, the procedures, because of the.
Procedure, I know the procedures, they have filed that application. You are coming up with this thing about the family tree. There's nothing mentioned anywhere. Here, 252 says any paternal aunt or maternal aunt or uncle can take the child in adoption. Where is the definition of paternal aunt or maternal aunt or uncle given out here? You don't know where it is. You want that we are going to make this relaxation, we will do whatever it is. This is not what it is conceived of when it is the question of child's welfare is concerned.
The adoption has to be, these things are there in the guideline. And they have been following the guideline and given the report. From the authority.
You
concerned,
said
I
in your,
got that
no,
on the-
Mr. Absolutely no. In your thing, you asked for two things. The first, an affidavit in terms which in Form 24, and the second, there should be the declaration being given by the mother. The mother declaration is given, affidavit in Form 24 is there. What is stopping you? That was the only innovation.
But the documents have come and that it after consideration as per the guideline, they have given the report. Now, they are the only authority, the state authority has to recommend it to the higher authority for acceptance. The guideline.
Why they are not doing it?
The procedure which they are following, not only.
Got to follow a procedure which is mandated under the law.
That's true.
Where is the law saying about the family tree?
But this is being followed, and in fact, they say that we are from different family tree. It is their affidavit only. I have shown page 82. Page 82, and that particular thing.
No, where is it said that it is required?
But exactly.
There is nothing. What is required is an affidavit in Form 24, which has been given.
Affidavit has been given.
And then,
Absolutely, it is given, but the requirement in the affidavit that.
so you are going to interpret that Form 24 affidavit should be in this manner by your chairman.
Chairman is nobody. Chairman.
Then
is not
who is
authority,
doing
not
it?
considered.
No, who is doing it?
But
Mr. Nath, who is doing it? Tell me.
The page 7, that is what the authority.
The authority at page 77 has given it, that we want these two. They have given. Then why are you stopping? What is stopping you from further progressing?
When kindly when the document submitted by them is not as per the norms.
They have
That has to
submitted
be-
at
that
page
has to be-
82. Mr. Nath, they have submitted the form in, you asked for two documents, which they have duly submitted. Then under what circumstances now you are coming up and saying that you are not going to progress with it?
The authority, as per the guidelines, is they have after receipt of these two documents, they found that family tree is not there.
Where is the requirement for a family tree?
That's not the authority, they are following this, I'll come up with that. I'll get that.
Tomorrow,
And the thing is-
tomorrow,
Yes, sir.
this is the matter tomorrow at 2 p.m. Come up with better things.
Yes, sir.
Actually, one second, ma'am.
Yes.
In affidavit, whichever has reflect, according to the report of the director or chairman of the CWS, Matrimony, CWC. In affidavit, which line, honorable, my colleague has again and again tell that family tree is different. I have mentioned, petitioner has mentioned, it is only mentioned according to their report, my lordship. In one report, their CWC chairman has mentioned that family tree also different.
Then I know
Yes,
the
ma'am.
chairman is causing the
Yes, ma'am.
problem. We'll hear the chairman next time.
Yes, ma'am.
Yes, yes.
Nobody, madam.
I know it. With tomorrow at 2.
Madam, submit, madam.
You
Chairman
don't
is-
know.
Chairman is
Mr.
nobody.
Nath,
Madam,
you are not aware of what is happening.
madam, I had a discussion, madam. I am
The
chair,
discussion is then what? Show me on,
I'll definitely.
no,
tomorrow-
tell me then. If you want, I can, I'll go ahead with it.
Madam, I'll apply. madam.
I'll do it.
Tomorrow I'll apply.
No, we'll do it now.
Madam, I'll apply.
Let me pass the direction, wait.
price.
Absolutely. Don't make this court.
Tomorrow,
Don't antagonize this court
I'll apply.
with your behavior out there.
I'm sorry, no, tomorrow I'll apply. I'll apply.
By the time I reached, item 5 was called.
Anyway, they have withdrawn.
There's an
None appeared
observation
on behalf of the High Court.
that,
Can't help it.
I don't need my appearance, but my lord, that if that may be taken care of by this honorable court, my humble prayer. my
So
lord.
none appeared for the High Court.
I missed it by a whisker. my lord.
So can't help it. I would have understood if there is an order being passed in your, against you, then you may have a right of
But
any
it
say.
was on me, my lord, to be
You know,
present
but
here.
it's-
Timing item
discussion.
51.
Withdraw.
I've taken instructions.
Mr. Ajay Sharma submits that the petitioner, he has instructions to withdraw the instant proceedings. So he, however, submits that the withdrawal of the instant petition should not, instant application should not prejudice the petitioner in any grounds of objection taken in any, if there is a requirement of filing a first appeal by the petitioner. Full stop. Taking into account the above, the instant proceeding stands closed on withdrawal. Full stop. The withdrawal of the instant petition shall not prejudice the petitioner to take such grounds of objection in the appeal if so necessary at a later stage.
Admission item 6.
Yes, what are you challenging?
My lord, I am for the respondent.
Hmm.
Trial court passed the one of mandatory injunction and they filed appeal. Their appeal was also dismissed. And against that dismissal order, they have filed appeal.
So you got an injunction,
My,
mandatory injunction. An appeal there against was filed.
my,
And that appeal was
dismissed.
dismissed.
Mine.
And it is against that they have come.
Mine.
Isn't it?
Yes, sir.
What is your case?
My lord, there is a suit part that is, my lord, schedule E. And that suit part falls in that number 8. And their suit line, they purchase it from that number 407. But they are claiming and they block my suit part. Then injunction was granted, mandatory injunction. It is admitted
What
that
is
they-
your prayer? In your plane? Isn't this your plane?
place 20, place 22. Sorry,
Page 27.
27.
And where the plaint is so and so, opposite party, plaintiff begs, where is the prayer?
Is 25.
Where is your prayer for mandatory injunction?
Mistake of the. In case 27,
No, no, no. In your plane?
They prayed for permanent injunction, that is.
This is a prohibitory injunction. Where is a mandatory injunction?
Yeah, in prayer, my lord. No, my lord, in prayer, permanent injunction was sought for.
Then how are you asking for mandatory injunction? Where is your direction out here?
My-
The relief being sought, that for removal of that particular thing,
That was mandated in plain, my lord, there is no need.
so unless you amend it,
Ah.
you cannot get that. So there has to be a part of the cause of action. Your cause of action is they should not block. But is it that they have blocked?
Already they have blocked. Okay,
When did
that's
they
the-
block? They blocked prior to the
Prior to
filing of the
filing,
suit.
yes, yes,
Then why there is no
That's true.
prayer in the
That's
main
true.
petition?
Yeah, sure.
So we have to interfere with this order,
That is correct.
isn't it?
Prayer I, my lord, it is there. Case 25.
Permanent injunction restraining so then to enter into the D schedule with the B schedule land as well as restraining
as-
to block so and so the private path within the C schedule land, creating any obstruction. So here you are asking for a prohibitory injunction. Now, where is your cause of action that they have blocked?
Not a-
Heard Mr. Idas, the learned counsel appearing on behalf of the petitioner. Mr. N. Hock appears on behalf of the respondents. First up, the supervisory jurisdiction of this court under Article 227 of the Constitution have been invoked to challenge the order dated 4/2/2023 passed in Miss Appeal number 10/2022, whereby the appeal was dismissed, thereby affirming the order passed by the learned trial court. Affirming the order passed by the learned Munsif number 2 in Ms. case number 140/2022, thereby granting a mandatory injunction directing the petitioners herein to reopen the block of the private that order. Directing the petitioner herein to remove the block and reopen the e-schedule land within 2 days from the date of receipt of the order. Pustak. This court have duly perused the plaint in title suit number 200/2022. Pustak. From a perusal of the plaint, I'm allowing your petition without hearing you. Without perusal of the, on perusal of the plaint, it is seen that the petitioners have herein have sought for a permanent injunction restraining the main defendants to enter into any part of the D schedule land within the B schedule land, as well as restraining to block the E schedule private part within the C schedule land, creating any obstruction and disturbance, the peaceful enjoyment of the plaint after so partition. Pustak. There is no cause of action mentioned in the plaint that the defendants oblique the petitioners herein had created a blockage in the e-schedule land in the suit. Full stop. Without the said aspect being there in the suit, comma, the question of granting of a mandatory injunction on the basis of an application being filed along with the plaint is totally misconceived. Full stop. Considering the above, this court therefore interferes with the order dated 22/8/2022 passed in Mize case number 140/2022 arising out of title suit number 200/2022, as well as the appellate order which is impugned in the instant proceedings, being the order dated 4/2023 passed in Miss Appeal number 10/2022. Full stop. Accordingly, the instant application stands allowed. Full stop. Before parting with the record, this court, however, observes that the interference so made to the impugned order dated 22/8/2022 passed in Mize case number 140/2022, as well as the subsequent order dated 4
4 to 2023.
4/2023 in Miss Appeal number 10/2022 shall not preclude the respondents herein who are the plaintiffs to seek necessary amendment in the plaint, as well as also file an application seeking mandatory injunction if so advised.
Item 7.
Here's what you are challenging.
Order dated 19/2023, thereby my two
Page,
parts, page, start from all page 16.
Huh?
Page 16, relevant para amal page
page
21,
62,
16.
16. Where is the plaint?
Plain page 22,
Page
22. In prayer model page 36. 35, start from page 35.
Both of you don't stay together? The plaintiff and the defendant number 4?
Yes, husband and wife.
Huh?
Husband and wife.
The language used out there, Mr. God? Asking the and illegally showing the value of the land and building mortgage to them at Viman and asking the defendant number 4 as well as the plaintiff as the guarantor to make payment and so and so. On receipt of the aforesaid notice, the plaintiff approached the defendant number 4. Huh? Both of you stay together and you are approaching
My lord,
and discuss the matter with him and obtain the statement of account from the defendant number 2. And on perusal of the statement of AR in showing that further the balance outstanding is shown at rupees so and so as on Viman and the alleged date of issue is so and so. Plaintiff and he approached the defendant personally and appointment. Have they taken any action on the 13-4?
They issued the notice, my lord. In earlier notice, they withdrawn.
13-2 notice they have issued. Then
Then, my lord, they withdrawn it. Then thereafter, my lord, they again issue the, they again issue the fresh notice, my lord. And then the 13-4 proceeding is pending for the district.
before the,
Deputy Commissioner, District Commissioner.
how? How is 13-4 pending before the deputy?
But 13, my lord, they applied for, my lord, physical possession. They applied for physical possession. of the
Physical
property.
possession. Physical possession will be done through the magistrate,
Yes, ma'am.
not the DRT.
Not, DRT, my lord, recently they filed a suit for recovery.
Do you have filed a suit?
Original application, my
Recovery.
lord.
For
Okay,
recovery.
but have you given up your surface proceedings?
My lord, what happened, initially when surface proceedings were initiated, those notices were, defect found to be erroneous and accordingly which were, withdrawn by the bank. And the complete suit is based upon that publication of the notices, which are as per the surface act, we are bound to publish those notices in the newspaper within 7 days of issuance of that notice. And the plaintiff, they agree with that publication only. My lord, in their prayer also, they have mentioned that due to that publication, their image got hurt and accordingly they have filed a suit for compensation. Our stand is simple is that for any action of 13-4,
there is an alternative remedy before
But
the,
13-4 action have you taken?
no, no physical position has been taken. Notice has been issued, but no,
13-4 states many things.
my lord.
13-4 may say that physical possession,
No,
have you
sir.
taken any constructive possession? Just for example, like on the action surface. action. Have you taken any notice, issued any publication that you have taken over possession?
Previous,
that,
yes.
that was given.
that is,
Subsequently,
it.
that was
Therefore,
Yes.
you have taken action under 13-4.
My lord,
So against the 13-4, this suit is filed.
my lord. The publication.
Now you have not gone on a 17.
No, 17, my lord, my case is so far relating to earlier notice. Earlier notice, they have withdrawn one.
But this is why how you are challenging by which year
2018 notice,
compensate.
my suit is for 2018 notice. Then they previously they issued the notice in the 2019 one. 2021. So for subsequent action, I'm not, so far this suit is concerned.
So you are, this suit is only against the withdrawn notice.
Yes,
My lord,
Withdrawn notice,
my lord.
and not against the
no,
subsequent.
no,
Then how it will be barred?
My lord, because there is provision under section 19. They can,
No, there is a provision under section 19. We are concerned with out here with 34, isn't it?
yes,
my lord.
34 says about what? Well, there was no action taken under 32, 13-2.
My lord.
No civil court shall have jurisdiction to entertain any suit or proceedings in respect of any matter which a debt recovery tribunal or an appellate tribunal is empowered by or under this act to determine, and no injunction shall be granted by it. Now, the debt recovery tribunal in this case will be empowered under section 19, 18, 17 to deal with what? Would only deal with when an action is taken under 13-4.
My lord.
And here the petitioner's specific case is that they are not against the 13-4.
They are against the publication of 13-4 notices. Those notices, their publication of 13-4 notices, which they have challenged in their suit. The notices as mentioned, those are 13-4 publication of 13-4 notices, my lord,
but
not 13-2. 13-2 notices is not required to be published. This publication are of 13-4 earlier, which are defective in nature.
So where is your cause of action?
my cause of action is regarding all the 2018 notice, they withdrawn. My lord, their withdrawal, my lord, amounts to that their notice were defective. So my reputation was put on the my lord, law on the basis of my lord illegal notices, my lord.
Huh?
My reputation was harmed because of their illegal action, my lord, because of the illegality they have.
Oh, but
withdrawn it.
how can you ask for this permanent injunction?
That may
How can you ask for this permanent injunction?
permanent injunction or
Page 37?
my lord. Well, if, that prayer I am ready to withdraw, my lord. That I may be allowed to withdraw that prayer, my lord, because
Then? And why are you asking this amount? Decree for declaration of his right title and interest to the effect the defendant number one has. What is this type of decree you are asking? What is this
my
decree?
lord, at least.
No, Mr. Gaur, what is this type of decree you are asking? A decree for declaration of right title and interest to the effect that the defendant number 1 and 3 has illegally manipulated. What is this? Declaration
Yeah.
of right title interest of what?
My lord,
That he has illegally manipulated.
my lord, there are reports of 3 chartered accounts, my lord.
What is this relief you are asking for? Second is a decree for declaration of plaintiff's right to the effect the defendant are liable to compensate for so and so. Decree for realization of against the defendant so and so.
Hello, so far my first prayer is, my lord, as per order dated 5/24, this honorable court, I am ready to.
No. I think this is a case on the order 17, say, over order 7, rule 11A and 11D. 11D for surface and 11A for does not disclose the cause of action.
No, cause of action, my lord.
No, nothing, because they have withdrawn that.
No, they have, they have withdrawn. That's why, my lord, my cause of action is there, my lord. Because if they have issued a illegal notice.
This is a case of misuse, flagrant misuse. This case rightly dismissed. We should not exercise jurisdiction. A and D rightly done. We add the words. Very well. I've heard the learned counsel peruse the materials and because they reveal the plaintiff has filed the suit basically on the subsequent
Well, there is a judgment of Honorable Supreme Court in reported in 2022, live life, page 7.
Go to Supreme Court, show that judgment. Heard Mr. J.C. Gaur, the learned counsel. Mr. Gaur, you don't have better things to do than filing this type of suits.
Well, at least, my
What
lord,
is this?
my lord, whatever.
You are fighting against a thing which is dead. It's a dead thing.
My lord, you can
They
see.
have withdrawn that notice.
My lord,
Matter over.
no, my lord, it is a real estate project, my lord. Now, they have published the note, my lord, who will purchase my building, my lord, now?
Huh?
No, my lord, because of their, this paper publication, my properties, my lord, at stake, my lord, now nobody will purchase these flats, my lord, in that building.
But before
So certainly, my lord, I have suffered a loss, my lord. How I'll repay, how, my lord, that depends.
Have they now initiated action under 13.2 and 13.5, 13.4 issue notice has been issued or not subsequently? And that having not been challenged here.
They have.
You have not challenged the subsequent one.
I'm not.
The ground he has taken before 13.4, 13.2 was issued.
Huh?
And thereupon 16 days time was also given. If he is so much thinking about his reputation, he could have settled that account at
Heard
that
Mr.
point of
J.C.
time.
Gaur, the learned counsel appearing on behalf of the petitioner. Mr. So-and-so appears on behalf of the respondent numbers 1, 2, and 3. Proceed. This is an application under Article 2 to 7 of the Constitution. Challenging the order dated 19/6/2023. And why should we entertain this type of petition? Plaint having been rejected, you have to file an appeal. Oh. So, heard Mr. J.C. Gaur, the learned counsel appearing on behalf of the petitioner. Mr. J. Bhorali, the learned counsel appears on behalf of the respondent. The petitioner herein have assailed the order dated 19/6/2023 passed in Mize case number 160/2022 arising out of title suit number 197/2020, whereby the plaint was rejected under Order 7, Rule 11A and D of the Code. It is a well-settled proposition of law that the that when when a plaint is rejected under order 711A and B of the code, comma, it amounts to a decree. Under such circumstances, the instant proceedings under Article 2 to 7 of the Constitution is not maintainable, for which the instant petition stands dismissed. Well, you do better things.
Time being item 50.
Yes, my lord, I'll just place some. Your lordship kindly see the suit was filed in 2015. Issues were framed in 2015, and thereafter petitioner, the plaintiff filed an application for amendment of plaint, my lord, that was allowed. That is prior to my institution, my lord. Again, my lord, additional issues were also framed in 2017. In 2018, my lord, my implead petition was there. I filed an application for implead me. So I was impleaded in 2018. Now, my lord, they have filed, my lord, now present implead petition, amendment petition in 2013 to 23, my lord.
You filed your written statement?
My lord, my inclusion order, my lord, that my, when my lord, I was inducted, my lord, I was impleaded, then immediately they filed an application for, my lord, review of the order. So review order was dismissed. Immediately now, my lord, they filed a application for amendment.
So you have
So
not
I have
filed
not-
your written statement?
No, no.
The moment you are brought in, Mr.
My lord,
Kumar,
I
the
can-
moment you are brought in the suit, the question will arise, the suit goes to the stage of pleadings,
My lord,
so the trial had not started.
earlier framing of
Earlier
issue has
gone.
done,
Earlier is gone.
my lord.
Now, they seek amendment now with your impleadment, they will like to include certain
But-
other properties. What is wrong?
No, I include another property, but my lord, your lordship kindly see that these are, my lord, they are known fact, my lord. It is not that these are subsequent event, my lord. But that is known to him.
When the suit is not at the stage of trial, where is the question of due diligence?
My lord, that due diligence also recorded here, my lord, that there is no, there is, in fact, there is no argument. That's why, my lord, it take cost of rupees 5,000 there, my lord, petition was allowed.
We reduce the 5,000.
No, my lord, that I'm not on that.
Unless if there-
There-
we do one thing.
My lord,
That day I passed one order similar like this. That the 5,000 he has given, the trial court has given, this court will honor that order. We dismiss your case with 5,000 cost and pay to him to the.
not
That day I
that, my
passed an order.
lord, not that.
We do that.
No, no,
Dismiss your petition with a cost of 5,000, you pay it to him.
dismiss, my lord, no.
Huh?
Your lordship, if your lordship, my lord, inclined to my, inclined to interfere with my lord, your lordship can dismiss them without any cost.
No,
That's
no,
what it
no,
has
no,
not been
no. That 5,000, he has to be unnecessarily the court put
my
5,000 cost. So I'm not touching that. I'm honoring the learned trial court's order.
My lord,
I dismiss your petition with cost of 5,000 and you pay that 5,000
that is my application, not his.
because this matter came up once, today in the morning twice, and now we are taking third.
No,
Oh,
sorry, my
let
lord,
the
I was in
plaintiff-
court number one, my lord, one high court matter was going on, my lord, that's why, my lord, I have to be there.
But she was very, otherwise she can
No,
argue second
she can
appeal,
argue,
but she
but
said
the-
that she's not going to argue, taking into account the senior
If-
counsel will
if
appeal.
now, but lordship put
And
my
with the senior counsel appealing, we have to impose cost.
that has to be. put
Because
by my
you
court.
like no adjournment on senior counsel grounds.
No, I am not paying for adjournment. They are, she also not paying for adjournment. It is just simply accommodation, my lord. Simply accommodation.
What to do? Dismiss or withdraw? File your written statement, go there.
Tomorrow is fixed for filing amended WS, amended plain. They have not yet
Ah,
filed amended.
Then you will file your WS.
Then they recast the,
Then only you will be given a copy.
recast the, that earlier,
Take all these grounds which you are taking here.
my lord. But observing that your lordship can, if your lordship, my lord, Okay,
Mr. T.J. Monto, the senior counsel assisted by so and so submits that the petitioner would be well advised to appear in the suit and file the written statement? He only submitted that the withdrawal of the instant proceeding should not the petitioner to raise the issues which have been raised in the instant proceedings before the learned trial court. Taking into account the above, the instant proceeding stands closed on withdrawal of liberty, however, it be there on the petitioner who have been newly pleaded as a respondent in the suit, a defendant in the suit, to file the written statement and take all such pleas as is available in the law.
Develop.
Item 8.
Tell me,
In this case,
so challenging.
challenging the order of injunction, my lord.
Ah,
They file a suit.
Huh?
And they file a suit.
Ah.
Respondent file a suit for declaration of right title interest and also recovery of position. And also they file a petition for temporary injunction. The learned court below has granted temporary injunction restricting us not to alienate the land, although we are in possession of the land.
You are?
We are in the possession of the land. Their suit is for declaration of right.
Where is that
title
order?
interest. Order
Trial court's order 18/11/2022.
11/2076.
Always so hereby restrained from making any alienation of the Schedule A land or from making any further construction of the Schedule A land during the pendency. Yes, now tell me,
Now, my lord, that order was challenged.
an appeal has been dismissed.
That the first instance, my lord, I filed and also filed a petition for stay of the order. That stay petition was dismissed rightly. Then we approached the Honorable Court by filing civil division petition, interlocutory application, my lord, 89, that this Honorable Court directed both the parties to maintain status quo in respect of the suit land. But ultimately, later on, that appeal finally dismissed. Upholding the land. Against that, I approached the Honorable
You
Court.
are in possession?
Yes, we are in possession.
Are you going to alienate?
Yes, because no. Oh, sorry, my lord. I am not alienated, but they are now going to dismiss the judgment. They are going to dismiss the judgment. By court.
File an injunction application before the trial court.
Yes, my lord. Then, my lord, what happened, my lord? After this Honorable Court passed an interim order, state both the order, as well as initial order and the appellate order. This Honorable Court stayed. During the pendency of these petitions, the opposite party, along with the OC, come to our lands, forcefully try to give permission to land to them. Dismantle our houses, taken away the articles from our houses. We file a complaint petition because OC is there. I file a complaint petition before the CJM against the OC as well as the plaintiffs. Then the learned CJM forwarded the case to the OC for restoring case. He is the accused. Case was forwarded to the OC. That OC. Then, my lord, we file a complaint before the DGP. When no in the absence, file a DGP. No action was also taken. Then again, we file another complaint to DGP. Then,
Mr. Ahmed,
hello.
the facts which you are narrating
Yes.
indicates that you should go to my next court, which is taking bench 5.
No. Then, my lord, we file a writ petition. Yes, we file a writ petition here.
There.
We file a writ petition. Your lordship, it is found. I filed an additional affidavit, but that was not on record. I give that order, my lord. This is the order. I felt an addition to bring all the facts in the record. Because injunction has been granted restraining us, my lord, but they are now trying.
But all said and done, you are before this court
Well,
where there was an injunction passed
Yes.
by the trial court directing that there
Not
shall
alienation.
not be any alienation
My lord,
as well as they
My-
should not construct.
my lord.
Now, against that, you filed an appeal. Appeal?
My lord.
That appeal was dismissed,
My lord.
and therefore you are before this
My
court. That's it.
My lord.
Now, my question therefore to you is very simple. Whether are you in possession of the land?
Yes.
Are you going to alienate?
No.
No. Are you thinking of construction?
No.
Then why you aggrieved?
Then, my lord, because they are now, because by,
For that, you need to file an injunction application before the trial court.
because already injunction application, they filed, trial court has already granted injunction, my lord. That is the problem,
Mr. J. Ahmed,
my lord.
I hope you have
No,
seen
my
that.
only simple.
No, kindly take out the CPC. Have you got the CPC
Yes.
with you? Yes.
Yes, my lord.
Now
My
read
only,
it,
my
read it.
only limited period is, my lord.
Let us go by the limited prayer only. Order 39, Rule 1A. Yes, 1A.
One. That any property in dispute in a suit is in danger or being wasted, damaged, or alienated by any party to the suit or wrongfully sold in execution of a degree.
B.
B. That the defendant threatens or intends to remove or dispose of his property with a view to his creditors.
So therefore, you will see 1A is for both parties,
Both parties.
plaintiff and the defendant. B is only for the plaintiff. So therefore, you can file an application out there for injunction, not to dispossess.
Right.
I can't do anything in 227.
I give the just you also can give the order passed by this honorable court.
Which one?
Yes.
What did I do?
I filed this additional affidavit. It can for this case also, man.
What is this?
What are they going to do, man?
So file an injunction application before the trial court.
Well, only my limited only fear, my lord. Let the both the parties maintain status. Why am now the
I cannot pass that order because I am not taking up the injunction matter. You have come before this court where there is an injunction order passed against you that you don't alienate and you don't construct. You say that you are not going to alienate, you are not going to construct. So your grievance in respect to the order is gone. Okay. Now you say that there is a threat for them to dispossess. You are at liberty. I'll observe that you can very well
My lord.
observe, file that application.
my lord and dispose of my lord that observation. Dispose of my lord. And in the meantime, status case to be maintained. Otherwise, they will, my lord, 500%, my lord, 500%, my lord. You loss of quality. I am a person. DCP. I approach the DCP court. Now, my lord, restriction I file, my lord.
Mr. Counsel, I cannot pass that.
That observation, my lord.
Yes, I'll give that. Heard Mr. J. Ahmed, the learned counsel appearing on behalf of the petitioner. You are appearing for whom?
For the respondents,
Mr. So-and-so appears on behalf of all the respondents. The supervisory jurisdiction of this court have been invoked, challenging the order dated 27/9/2023, passed in Miss Appeal number 4/2023, whereby the learned court of the Civil Judge Senior Division Morigaon, hereinafter referred to as the learned First Appellate Court, dismissed the appeal and upheld the order dated 18/11/2022, passed in Ms. J case number 136/2022 by the learned court of the Munsif number 1 Morigaon, for short the learned trial court, in title suit number
183.
183/2021. Full stop. This court have duly perused the order dated 18/11/2021-22, passed by the learned trial court, whereby the learned trial court had granted a temporary injunction, thereby restraining the petitioners herein from making any alienation of the suit Schedule A land or from making any further construction over the Schedule A land as mentioned in the plaint during the pendency of the title suit. Full stop. Being aggrieved, the petitioners herein had filed an appeal before the learned First Appellate Court, which was registered and numbered as Miss Appeal number 4/2023. Full stop. The learned First Appellate Court, having duly taken note of the three golden principles for grant of an injunction and being in conformity with the observations made by the learned trial court, affirmed the order dated 18/11/2022 passed in Ms. case number at 136/2022 by the learned trial court. It is under such circumstances, the present application has been filed by invoking the supervisory jurisdiction of this court. Full stop. This court, having noticed that the learned trial court as well as the learned First Appellate Court have duly taken note, this court have duly taken note of, this court have heard the learned counsels appearing on behalf of the parties. Full stop. Upon hearing the learned counsels and upon perusal of the materials on record, more particularly the orders dated 18/11/2022 passed by the learned trial court, as well as the order dated 27/9/2023 passed by the learned appellate court. It transpires that the court of the first instance, after duly applying the materials, the three golden principles for grant of an injunction, have granted the injunction in favor of the plaintiffs to the effect that the defendants, that is the petitioners herein, shall not alienate the suit property as described in Schedule A to the plaint, as well as also shall not raise any construction. Full stop. The learned First Appellate Court have also duly taken note of the three golden principles for grant of an injunction and have confirmed the findings passed by the learned First Appellate Court, learned trial court. Full stop. Taking into account, full stop, this court do not find any ground to interfere with the findings so arrived at by the learned trial court in granting the injunction. Full stop. This court further made a pointed query upon Mr. J. Ahmed, the learned counsel appearing on behalf of the petitioner, as to whether the petitioners intend to alienate the Schedule A property as well as to raise constructions. Mr. J. Ahmed submits that the petitioners are not taking such steps to alienate the Schedule A property as well as to raise any construction. He, however, submitted that the petitioners herein are posed with a threat by the plaintiffs, who are the respondents herein, to be posed with the threat from the plaintiffs oblique the respondents herein to dispossess the petitioners.
Already taken steps.
Possess the petitioners and had taken certain steps. Full stop. He is therefore submitted that certain orders be passed directing maintenance of the status quo by this court. Full stop. This court, having given an anxious consideration, is of the opinion that as the petitioners herein are not contemplating of alienating the Schedule A land, as well as are also not contemplating to raise any construction, full stop, the petitioner therefore do not have any grievance against the order dated 18/11/2022 passed by the learned trial court, which was affirmed by the order dated 27/9/2023 passed by the learned First Appellate Court. As regards the request, as regards the prayer made by Mr. J. Ahmed to the effect that there should be an order of status quo be passed by this court. This court is of the opinion that such orders cannot be passed by this court in exercise of the jurisdiction under Article 2 to 7 of the Constitution, as the jurisdiction is limited in that extent. Be that as it may, the petitioner herein, if so advised, would be at liberty to file an application seeking appropriate injunction under Order 39, Rule 1A of the Code of Civil Procedure before the learned trial court. And if such application is filed, the learned trial court would duly consider the same in accordance with law.
Malala, one thing. That suit was filed on 2021. They are taking time after time, and even not, those are the orders, my lord. Those are the orders, my lord. Even they are not taking.
Mr. J. Ahmed,
Let that suit.
you have you seen my recent judgment on no adjournment business? Take that. Take that help.
Deeply obliged.
Item 9.
What is this?
Your Lordship,
Ah.
petitioner implement petition was dismissed.
Petitioners?
Implement order, 100 page 17,
Page,
annexure 17, page 117,
171,
117.
117.
Petitioner implement petition was rejected on the ground of defendant number 2 objection, not by the plaintiff.
The petitioner, defendant number 6 and 7 filed petition under Order 9 Rule 7 read with section 1 praying for setting aside the ex parte passed against them in the suit and prayed for admitting and accepting the written statement. That is it.
No. No.
Which
Your
order you are
Lordship.
challenging?
117,
That is
annexure 17.
Extra 70. Okay, yes. One Suraj Saha filed an application
Lordship.
under Order Iman read with section A stating the fact the petitioner has purchased a plot of land described in the schedule so and so. The defendant number 1 of the suit filed written objection that the petitioner is a stranger in respect to You are defend number 1.
No, my lord, I am the plaintiff.
Defend number 1.
Defendant number two.
Who is defend number 1?
He is defendant number 1.
Oh, yes, come over. You are the main person. Who are you? You have any objection?
I am the plaintiff. I have not filed any objection.
What is your objection?
Objection, that is a page.
No, tell me.
Your Lordship, mainly on the ground that the property is a joint property. And till date, it has not been divided in meets and bounds. But during the pendency of the title suit, which was filed by the plaintiff, partitioning the entire property into 1/8 share. Two of the co-owners have alienated the property to this Suraj Saha. So that couldn't have been done without our consent. And secondly, there was a.
No, everything is understandable. Now, the moment he comes in, the transfer he has happened, two of the properties.
Yes.
Now, did they transfer their share? It's a suit for partition
Yes, it's a suit.
where two of the co-owners have transferred their part of the share.
Yes, yes.
May not be partition, that's a different thing, but their part of the share to the him. He stands now in the shoes of those two co-owners. Then why is he not a party, necessary party? He's not a suit for specific performance. The necessary party. It is the moment he purchases. You see section 44 of the Transfer of Property Act. Oh, Mr. S. Doctor, you are arguing before this court without the book. I congratulate you. Transfer of Property Act.
And another ground was that in the title suit, there was a status quo order which was operating. So
Already
that has
status quo
already been,
vacated.
that has been violated.
Status quo order, it has been done, for which you need to file a suit.
Separate suit had been filed.
That the transfer is a nullity. Have you filed any
Yes,
counterclaim?
yes, that is already pending. They filed a separate
Injunction-
suit also challenging this sale deed, subsequent sale deed.
You have filed the suit.
Yes.
So that is another aspect, but
Injunction is
here
already vacated.
but the suit has not yet been set aside.
No.
See section 44. What is it right? He also steps into the shoes of those two
Those co-owners.
and seek partition, isn't it? So if that be so, why he is not a necessary party? Or you want to, by not allowing him to impede him, you want to make him his suit bad. It seems that is the reason why. Yes. Leho. Heard Miss So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. Azota appears on behalf of the respondent number
2.
2. And Mr. So-and-so appears for the respondent number 1. Full stop. The supervisory jurisdiction of this court have been invoked to challenge the order dated 10/7/2024 passed in Mizi case number 254/2020 arising out of title suit number 183/2021, whereby the application so filed by the petitioner under Order 1 Rule 10(2) read with section 151 of the Code of Civil Procedure 1908, for short, the code was rejected with a cost of ₹2,000. From the materials on record, it is seen that the petitioner herein, from the materials on record, it is seen that the respondent number 1 herein has filed a suit being title suit number 183/2021, seeking a decree for partition of the properties as described in the schedule to the plaintiff. Who sold it to you?
The
Which-
Proforma respondent 9 and 10. Proforma respondent number 9 and 10, Rajdeep and Deep Shekhar.
In the plaint. Where's the plaint? You have enclosed everything.
Plaintiff,
Where's the plaint? Who sold it to you?
Proforma respondent 9 and 10,
Number?
present.
Huh? What is
Present.
the suit number? Where's the plaint?
183, 2000.
Plaint.
There'll be defendants 6 and 7. Rajshekhar, Deep Shekhar.
6 and Rajshekhar and
Deep Shekhar.
Deep Shekhar. Okay.
It is at page 24.
Full stop. It is seen from the records that the defendant number 6 and 7 of title suit number 183/2021 sold their part of the share to the petitioner herein by a deed, registered deed of sale bearing deed number 3553 dated 11/9/2023. This court have duly taken note of section 44 of the Transfer of Property Act 1882, which stipulates, give it to me. Which stipulates that one of two or more co-owners of an immovable property legally competent in that behalf transfers his share of such property or any interest thereon. The transferee acquires as to such share or interest, and so far as is necessary to give effect to the transfer, the transferor's right to joint possession or other common or part enjoyment of the property, and to enforce a partition of the same, but subject to the conditions and liabilities effective at the date of the transfer, the share or interest so transferred. Full stop. Taking into account the above, comma, as the defendant number 6 and 7 were co-owners of the property, of the suit property, full stop, and they being legally competent, the deed of sale was executed. Full stop. Deed of sale bearing deed number 3553 dated 11/9/2023 was executed in favor of the petitioner herein. Full stop. Under such circumstances, the petitioner stands in the footing of the respondent numbers, defendant number 6 and 7 in the suit, and therefore would be entitled to take part in the said partition proceedings, which is the subject matter of the suit. Consequently, it is therefore the opinion of this court that the learned trial court ought to have allowed the application under Order 1 Rule 10(2) of the code so filed by the petitioner. Having not done so, that too, at the objection filed by the defendant number 1, shocks and surprises this court, for which this court invokes its supervisory jurisdiction under Article 2 to 7 of the Constitution and interferes with the order dated 10/7/2024 impugned in the instant proceedings. Full stop. This court further allows the application filed under Order 1 Rule 10(2) of the code, being petition number 528/32, filed before the learned trial court, and impledes the petitioner herein as the defendant number 12 to the said suit. Full stop. You have a copy of the plaint. Ms. So-and-so submits that she has a copy of the plaint along with the documents which have been filed along with the plaint. There's a stay? There's a stay? No stay?
No, it was status quo, stay is
Stay
granted
honorable counsel.
during the pendency of stay, the respondent number 2, 9 and 10 sold the property. That's why their suit was expertise. Later on, their written statement was accepted by this honorable tribunal. Honorable court.
Submits that she has got the plaint as well as the copies which have been filed along with the plaint. Full stop. She further submits that she would be submitting the written statement by,
The defendant number 6 and 7 written statement was accepted.
I'm not on it. Are you going to file written statement or not? By, today is what?
the 20 days minimum.
Okay. Vicky Perry? 14 na? By 16th of June 2025. Kusto. Taking into account the above, this court disposes of the instant petition with the following observations and directions. Number one, the order dated 10/7/2024 passed in Mizi case number 254/2024 is interfered with and set aside. Full stop. Number two, the petitioner herein, the petitioner herein, who is the applicant in petition number 528/32, is impleaded as the defendant number 12 in the said suit. Number three, the petitioner is herein is given the liberty to file their written statement before the learned trial court on or before 16th of June 2025. The above the petition stands.
I yield.
Item 10.
Your Lordship. Your Lordship, the issue was whether the vigorous passenger traveling in a goods vehicle is covered under the policy. The Lordship, that they referred to a judgment. Rajesh
SBI
Kumar
one,
Singh,
that one.
yes, Munawara Khatun Lordship.
What is your ground of objection?
Lord, that judgment, Lordship, Munawara Khatun judgment, Lordship, had laid upon the judgment of Saju P. Paul, Lordship. And that Saju P. Paul judgment is the date of accident, my lord, is before 1994 amendment, Lordship. Because there is a difference of term between the goods carriage and the goods vehicle. So that after 1994 amendment, Lordship, the term has been used as goods carriage. Goods carriage.
No,
And the
here you
judgment-
have to been directed to pay and recover.
Yes.
Then
Yes, Lordship, that is why, Lordship, I am relying upon one judgment passed by our High Court, Lordship.
that is by
That-
Justice Chaudhary.
Yes, that Munawara Khatun judgment and Saju P. judgment has been discussed, my lord, thoroughly, man.
But that judgment has not been taken into account, where the Supreme Court held that the High Court, having not taken into account the earlier judgment, which I have referred to on the last occasion, the Supreme Court held that because of that, interfered with the order and directed to pay and recover.
Lordship, for a moment, Lordship. Oh, sorry. So our High Court, my lord, Lordship, may kindly see page 11, para 31.
Para?
31, page 11. Because these three judgments have been discussed, my lord. So my lordship, my ground is that no pay and recovery orders should have been made, my lord.
What is the judgment I referred on that day to you?
Lordship, that Rajesh Kumar Singh, this is my lord, Munawara Khatun versus Rajesh Kumar Singh. That judgment is from our High Court only, my lord. Our High Court judgment was.
The
accepted.
judgment of Justice Sapre.
Yes, my lord.
What is the name?
Munawara Khatun, Manura. I have the judgment.
You have it?
Yes. Lordship may kindly see page number 5, para 17. Peculiar facts of the case, my lord.
Recently, another judgment has come. I think Justice Amanullah's judgment regarding the tractor. You have read it? The tractor having another one tied with it.
Trailer.
What is that?
Trailer.
The trailer being tied. The trailer was not insured, but the tractor being tied with the trailer, therefore it is insured. So, you pay, recover.
After discussing the judgment, Lordship, our High Court, my lord, in para 36, that judgment I have referred to,
Has this judgment been discussed?
Munwar Khatun judgment. That judgment has been discussed, my lord. That judgment has been discussed by our High Court.
Let us see where.
Yes, Lordship. Lordship may kindly see. uh, Page 9, my lord, para 23. Para 23.
Though it has mentioned, paragraph 23 says the matter involved therein also pertains to gratuitous passenger and fastening the liability to pay compensation to the claimant. Apart from the other decisions, the Supreme Court therein considered the decision of so and so.
Kindly see para 24, Because the Sajupal judgment, my lord, is in respect of an accident which had taken place prior to the amendment of 1994. The definition was different, goods vehicle and goods carriage.
Thirty-one, it is seen from the decision in Baljit Kaur, Sarjuvar and Manwara, the insurance company is not liable to pay compensation for the death of the Iman, and therefore the insurance company is not liable to indemnify the award. This is the position of the has enunciated. Is it true? Is this a proper reading of the judgment? Paragraph 31?
Yes, my lord, under 140, Article 142,
I'm not on that, Mr. Goilda. Paragraph 31, is it the correct proposition of law which the ordinance bench have stated? Here there was again a direction to pay.
actually, the conclusion was that, my lord, the insurance company is not liable. There are
No, no,
36
no, no,
magazine,
no.
my lord.
Here
there are
it says,
36.
in view of the directions to the Iman that they are being the insurers of the area which was found involved in the accident due to negligence and need to be issued directing the area to first pay the awarded amount and then recover it so and so in the execution proceeding as per law in terms of Iman quoted above. According the appeal succeed and the impugned order is modified. So this is what has been given.
Yes.
Then this seems to be wrong. Paragraph 31.
Basically, the question before us, lordship, whether the claims tribunal could have given the pay and recovery order, because the deceased person was a stranger to the insurance policy. His liability is not covered.
Deceased person is not the stranger. We are not concerned with the deceased person. We are concerned with first that he was in a vehicle which is insured.
That is insured, and this was a goods carriage, lordship. He was not supposed to travel in that vehicle. Either he should have traveled as a person
So therefore,
engaged
you
for
want to pay
operation or
and then
maintenance.
recover it. Therefore, the court held it. You pay first and recover. We are only on that question. We are not on the other aspects as to whether the payment was to be made, how it is to be made. I'm not on that. The question is you pay and then recover. You have been given the right to recover.
That is there, lordship. That has been given, that right has been given to us. Lordship, my
And this,
submission is,
and paragraph 31, can you read it? It is seen from the decision of so and so and Manwara Khatun that the insurance company is not liable to pay compensation for the death of or injury to any gratuitous passenger, and therefore the insurance company is not liable to indemnify the award. This is the position of the Supreme Court has enunciated. That is wrong. In such a, the question that arises in the instant appeal as to whether it can be within the purview of the court power vested in the tribunal to make the direction. Now here, the court, the High Court had interfered in this Manwara Khatun's judgment. Kindly see this.
yes, lordship. Manwara Khatun judgment,
These appeals are filed against the common final judgment of the Iman, whereby the High Court dismissed the appeals filed by the appellants herein for enhancement of the compensation anyhow, we find on so and so, Manwara Khatun's wife of so and so claiming total compensation of rupees so and so, so and so. The tribunal by the award partly allowed the remand. The tribunal held that the Tata Sumo was driven by so and so. The tribunal remand held that all the passengers, including the deceased, were traveling in Tata Sumo for hire and hence they were held to be gratuitous. It was held that due to this reason, the United so and so was not liable. According, the insurer was exonerated from the liability and the award was passed only against the owner in both the cases. So far as the owner of so and so, both were not liable in. Dissatisfied of the award dated so and so were filed before the High Court by the claimant by enhancement of the compensation amount awarded demand. The other ground raised before the High Court was that it was the liability of the insurance company of the offender to compensate the claimant jointly and severally with the owner of the Iman, and in the event the direction to pay the compensation by the insurer of the offending and then recovering from the insurance. The High Court dismissed the appeal filed by the claimants and held that the insurer was not liable because the passenger or occupants were being carried in a private way as a gratuitous way, aggrieved by their sale. So, that is why the Supreme Court interfered with this.
My lord, my submission is that, my lord. Manwara Khatun judgment had relied upon the judgment of Saju P. Paul. And Saju P. Paul judgment, my lord, is in respect of a incident that took place prior to 1994 amendment. And lordship, 1994.
Are you saying that the judgment of 2017 is wrong? I'm asking. Parin Puri. Are you saying? If you are not stating, then the judgment of the coordinate bench is wrong.
My submission is that only that under Article 142, only apex court can pass the judgment of pain recovery in respect of previous passenger. Because this was not passed under Article 141.
So you mean to say that I allow your appeal and then this claimant go to the Supreme Court to get an order of this type? Is it something like that? Where the court did not say, interfered with, can we see what the court did? In our opinion, we may say, as we notice that it is the subject matter of several decisions in Baljit Kaur and so and so. The question which fell for consideration is so and so demand. The fact of the case are somehow similar and identical to the mentioned here in the offending area. It is for that reason the insurer were exonerated. Also, held that the victim was the aggressor of this court and issued direction against the insurer vehicle to first satisfy the awarded sum and then recover the same from the insured in the same proceeding. So we find no merit in any of the submissions. Firstly, as mentioned above, we found marked similarity in the facts of this case and the one in so and so. Secondly, merely because the compensation has not yet been paid to the claimant though the case is quite old, like so and so, it cannot be a ground to deny the claimant the relief claimed in the appeals. Thirdly, this court have already considered and rejected the argument regarding non-granting of the relief of the nature claimed therein due to the pendency of reference to the event, as would be clear from paragraph 26 of the judgment in Swell. That upon the learned counsel for the appellant stated at the bar that the reference made to the has since been disposed of, keeping the issue undecided. It is for this reason also the argument does not survive. It is for all these reasons we find no good ground to take a different view from the one consistently being taken by this court in all previous decisions as referred. In view of the above, the foregoing discussions, we have the view that the direction to United so and so, they being the insurer of the offending vehicle, which was found involved in the accident due to negligence of the driver, needs to be issued directing them so and so to first pay the awarded sum to the so and then recover the same. So, the court needn't say that 142. 1 month, take an adjournment. You may get the appeal, let me, till 1 month, no, I am there. See, after all, these are benevolent litigation. One has to pay and recover, and then you recover it. How you recover it, they will know what to do. You know how to do. There is already a direction. You need to just make the payment and then you start the proceedings against them. Where is he going? This person is going to go. In fact, that is the recent judgment in that tractors case. If you look into it, the court made it also made various observations as regards why this is being required to be given. Because the carriage was not insured. What was insured was the tractor. Therefore, it says that when the tractor is connected to the carriage, although the carriage was not, meaning thereby what? The entire basis of a gratuitous passenger is gone. In the tractor, nobody is allowed to sit. What has happened here? They put a trailer with the tractor. And these people were sitting out there. And they say that as an insured vehicle is connected with the trailer, and the insured vehicle committed the area, they are liable. The very edifice of a gratuitous passenger, which is there in the judgment, or in these judgments, have been taken for a 1 month or dismiss.
After Lordship, Lord.
No, I will give you chance. But for me, I am not going to interfere with this.
It's up to the Lordship, Lord. It's up to the Lordship.
I can do one thing. Because why I don't want, you see, if I admit this thing, I'll direct you to stay subject to payment. Okay. Now what happens, the payment, if I subject it, I'll ask them to pay you 50% or 60%. Then you cannot control this thing which is given in paragraph 51, 52, 53. And at the end of the day, the claimant is actually affected, not the lawyer. I hope you understand. I'm more concerned about the claimant. The claimant gets it. So that is it. Because here the court has otherwise. Is there any other ground for interference?
No, my lord. This is the only ground.
Because now there is no reference also to that point in view of Manwara Khatri. The reference, this point remained undecided.
In fact, my lord, this was supposed to be decided because the amount was small. That is why Honorable Apex Court refused to decide that point because amount was ready to be given to the claimant because amount was very small.
At the end of the day, these people will get it and recover it from this person.
Lordship, passing on.
Which one? Option I'm giving you.
Lordship, may pass any order. Lordship.
Heard Mr. T. Goenka, the Lalit Council, appearing on behalf of the appellant. This is an appeal filed under section 173 of the Motor Vehicles Act 1988, challenging the judgment and award dated 29/1/2025, passed in MAC case number 1899/2017, whereby the claimant whereby the claimants have been awarded a total compensation of rupees 16 lakhs 92,000 and payment and the said amount along with interest at the rate of 9% from the date of filing of the claim petition. First, the learned counsel appearing on behalf of the appellant submitted that the only ground of objection so taken in the instant appeal is that the court having found that the
Paragraph 46, page number 34.
having found that the deceased was not a laborer of the tractor, nor the authorized representative of the company. And as he was traveling as a gratuitous passenger, the learned tribunal could not have directed the appellant insurance company to make payment of the amount so awarded and thereupon to recover the entire amount from the owner of the vehicle in due course of time. First, in that regard, the learned counsel has referred to the judgment of a coordinate bench of this court in the case of Oriental Insurance Co. Limited versus RT Chick and others, reported in
2019, 3 GLT.
2019 3 GLT 47. Taking into account the issue, the ground of objection taken in the instant appeal, the point for determination which arises is as to whether the learned tribunal was justified in directing payment of the judge awarded amount to the claimants by the appellant insurance company and thereupon to recover from the owner. First, this court have duly perused the judgment of the coordinate bench in the case of Oriental Insurance Company versus RT Chick and others, reported in 2019 3 GLT 47. First, without going much into the said judgment, this court finds it very relevant to take note of the judgment of the Supreme Court in the case of Manuara Khatun and others versus Rajesh Kumar Singh and others, reported in 2017 4 SCC 796. In the same judgment, Full stop. Seven nine six, as the said judgment has a direct bearing on the issue involved. Full stop. The facts in Manwara Khatun, Supra, was that a claim proceedings was filed by the wife of his deceased, which was registered as MSC case number 653/2001. And there was another claim proceedings filed being MSC case number 652/2001 before the Motor Accidents Claims Tribunal, Nagaon. And the facts of the case in Manwara Khatun were that two claim proceedings were filed by the claimant of deceased being MSC case number 652/2001 and MSC case number 653/2001. Claiming compensation on account of the death of the deceased. First, the learned tribunal taking into account that the deceased were gratuitous passengers, exonerated the insurance company and directed the payment to be made by the owner. First, being aggrieved by the said award, two appeals were filed being MSC appeal number 7/2009 and MSC appeal number 8/2009 before this court, seeking enhancement of the compensation and also for a direction that the amounts be satisfied by the insurance company, and the insurance company can later on recover it from the owner. These appeals were dismissed by this court, by the common judgment and order dated 22/6/2012. Full stop. Being aggrieved, the claimants approached the Supreme Court. Full stop. The Supreme Court was seized with the specific question as to whether this court was justified in not issuing directions to the insurance company to make the payment and then recover it from the owner. First, the Supreme Court in the said judgment categorically observed that this court failed to exercise its jurisdiction in making payment by the appellant, by the insurance company, and then to recover it from the owner. Full stop. This aspect can be seen from a perusal of paragraph number 16 to 21, 22 of the said judgment, which is reproduced hereunder. Full stop. Taking into account the ground of objection so taken, the sole ground of objection so taken, it is the opinion of the court that the learned tribunal had not committed any error in directing payment by the appellant insurance company and then to recover. Full stop. Accordingly, the instant appeal, this court finds no ground in the instant appeal for which the instant appeal stands dismissed. Full stop. I stand dismissed.
11,
Yes, Mr. Goswami, what are you challenging?
This is appeal, I'm appealing for the claimant appellate. This is for enhancement of the,
Are you asking for enhancement? Enhancement or dismissal?
is for enhancement. It is for enhancement. Because what happened in this case, my husband, he was an employee, he was working in a masjid, he was working in a mosque. And we have quantified his amount, we have shown him, we have given the substantive evidence of this employees. And we have even exhibited everything, but this lower tribunal has with manifested error, has not taken into account and it hasn't been reflected.
No, wait.
They have taken a
What
notional
evidence
income.
did you give that he was earning 10,000?
So, with all due respect, my, your lordship may kindly peruse, this, ground number 3. Ground number 3.
I'm not on ground number 3. What
So
is the evidence
has
you have
that
given?
He was the imam, the secretary of the mosque has.
What evidence you have given that he was earning 10,000 rupees per
The
month?
evidence that has been, the corroborated evidence is that he has given the salary certificate of what salary certificate has been given. And that salary certificate has been proved by the employee. Employee over here is that secretary of that particular mosque. So as we have already successfully quantified his number, so how can his come under this canopy of the notional income? Because notional income is totally a different subject where things cannot be quantified and it remains on the subject to the interpretation of the court. So this is not a notional income. He is a earning member.
No case.
So my humble submission before your lordship is that does this edifice of this or does this umbrella term of notional income?
Use the exhibit 4 next time when the matter is used. How much time?
15 days.
Is the matter after 2 weeks. In the meantime, the learned counsel for the appellant shall produce the exhibit 4.
supplementary item 52,
Which one?
Section 8 petition rejected. Section 8 petition being rejected by.
I know that. Now I am asking you. You want to go for arbitration?
Yes, I asked my client, he said yes, client is.
Your case is that the dispute is arbitrable. Why? Let us see the plain
That your lordship will find in page 16.
page.
16.
Summary input to let me know. When did the dispute arose?
As per their own cause of action, your lordship. First in 16,
Huh?
2016 first.
Then how are you referring to this agreement, lease deed?
The this deed has come to an end.
Then?
But-
It is not stamped? It doesn't have a stamp?
Yes,
It's
but
not registered?
but
So
still,
it can't be taken into account. Finished. Dismiss on that ground. That's your ground, I suppose, Mr. Talukdar. Or is it I am adding?
That is one of the ground. And second ground, my lord, is.
Chalo.
And second ground is, my lord, rent, my lord, legislation. As per Vidya Dolia, your lordship is aware, my lord, when it is holding the field and it is governed by, my lord, the rent control legislation, that cannot
Not
be.
only that, not Vidya only, we go by Boozalan has not been set aside.
Yes, yes.
So we go by
Boozalan not
Boozalan.
satisfied. Correct, my lord. Only-
Vidya has stated
Himanshu-
out there,
Himanshu.
paragraph number 83,
Yes.
he may be referring to that.
Yes.
That's a different thing. But then also it says that he will say that however, in some cases where arbitration can be done.
Correct.
But arbitration can be done only in respect to an agreement which can be looked into. This document cannot be looked into.
Yes,
That they do.
yes, my lord. Correct.
your lordship,
With cost, there's a stay.
You stay, my lord, and this is only for delaying the, my lord, suit.
Oh,
There is a stay, my lord.
hey,
Yes.
from 2024.
Yes.
No, 2024 every month is 63,400. You are losing,
Yes,
he's not
correct.
paying.
No payment.
Huh?
Correct.
63,000 into 400 into, hey, calculator into 10, 12, 7 lakhs. Easy calculation, cost. This is an application file of the stuff. The why is this 227? Not 115? Huh? When did you file it?
fine.
9/2024.
Yes.
When was the order passed?
Order was for 23/9,
Huh?
23/9/2024.
6/1/2024. And you filed it on 9. On the ground of limitation also this goes. But Lekhok. Heard Mr. R. Sharma, the learned counsel appearing on behalf of the petitioner, and Mr. S.R. Talukdar appearing on
SK,
behalf
my
of,
lord.
huh?
SK, my lord.
Huh?
SK Talukdar.
S.K. Talukdar, appearing on behalf of the respondents. Respondent, na?
Respondent, my lord. Sole
These
respondent.
petitioners and respondent. The supervisory jurisdiction of the court have been invoked, challenging the order dated 6/1/2024 passed in miscellaneous appeal number 02/2023. How are you challenging this also?
No,
Arbitration economics.
we went for
You
first-
cannot challenge this. And allowing an application by challenge under 37. But dismissing an application, you have to go under section 16, matter over, it has to be done only under 34.
We filed an appeal. First appeal was also dismissed about.
Understood, that is why I'm saying.
Your lordship that 37,
Refusing to refer the parties to arbitration under section 8. So this is an appeal against that. So therefore you are coming under 227. Supervisory jurisdiction has been invoked challenging the order dated 6/1/2024. Passed in miscellaneous appeal number 02/2023. Whereby the said appeal was dismissed. Thereby affirming the order dated 23/2023 passed by the learned civil judge junior division number 1 Lakhimpur at North Lakhimpur in Mirze case number 52/2022. Full stop. To ascertain the dispute involved, this court finds it relevant to take note of the facts which led to the filing of the instant proceedings. Full stop. The respondent herein, as plaintiff, had filed a suit against the petitioners herein, who were the defendants, before the court of the learned civil judge Lakhimpur at North Lakhimpur, seeking a decree for eviction against the defendants, recovery of khas possession of the suit property from the defendants in favor of the plaintiff, as well as for a decree for mean profit at the rate of rupees 300 only per diem against the defendants since 11/9/2019 to till recovery of the possession of the suit property from the defendant. Full stop. The suit was filed, no, full stop. It is very relevant to take note of that from a perusal of the plaint, the suit property is situated within the Lakhimpur town and would come within the purview of the Assam Urban Area Rent Control Act 1972. In terms with section 2G of the Act of 1972, bracketed for short the Act of 1972. In terms with section 2G of the said Act of 1972. First, the suit, a perusal of the plaint reveals that the defendants this agreement is with Disnet.
Yes,
Then who are you?
this net has been taken over by us.
A perusal of the said agreement, a perusal of the plaint reveals that the defendant, that the plaintiff had entered into an agreement with one MS Disnet Wireless Limited in the month of August 2007, thereby leasing out the property as described in the schedule to the plaint. Full stop. it is alleged in the plaint that the defendant that the plaintiff that the said MS Disnet Wireless Limited was taken over by the GTL Infrastructure Limited, and the said company continued to remain as a tenant of the plaintiff. First, it has been alleged in the plaint that the defendants in the suit are defaulter in payment of rent, and further, the defendant are liable to be also evicted in terms with Section 51A of the Act of 1972, which is violation of the provisions of subsection M, O, P of Section 108 of the Transfer Property Act 1882. First, the defendant, after appearing in the suit, filed an application under Section 8 of the Arbitration and Conciliation Act 1996, for short, the Act of 1996, seeking that the dispute, stating inter alia that the dispute between the plaintiff and the defendant are covered by an arbitration agreement. And as such, the suit be dismissed and the parties being referred to arbitration. First, the said application so filed was registered and numbered as Ms. case number 52/2022. আগতে ক'ৰবাত লিখি দিব হা, suit to number হল title suit number 44/20 হা. What is the present number?
5/2020.
5/2020.
2020.
Suit.
Now it's a 44. Initially it was 5.
5. Initially 5 as 5, na? /2020.
20. Yes.
And then now
Renumbered as 44/2020.
20. প্ৰথমতে 5 আছে, তেতিয়া file কৰিলে suit এটা which was registered and numbered as title suit number 5 before the court of the civil judge at North Lakhimpur. The case of the plaintiff, সেইখিনি মই ক'লো, তাৰপিছত ক'ব, he filed their objection, the defendants appeared and filed an application under section 5 and section 8. Where is that?
Page 56.
5, 8. Which was registered and numbered as Ms. case number 52/2022. Subsequently, in view of the change in the pecuniary jurisdiction of the court, the suit was transferred to the Court of the Civil Judge, Junior Division number 1 at Lakhimpur, North Lakhimpur, and the suit was renumbered as title suit number 44/2020. The respondents herein, the respondents herein who were the plaintiff filed written objection to the application filed under section 5 and 8 of the Act of 1996. First, where's the order?
The first order. That is at page 114.
The learned trial court, that is the Court of the Civil Judge, Junior Division number 1, Lakhimpur, by an order dated 23/2023, dismissed the said application. You gave a photocopy.
We gave a photocopy, but that agreement was supplied by the plaintiff themselves. So that then strict compliance of 8(3) did not be done because the plaintiff themselves are relying on the document. Then I did not give certified copy.
Was dismissed on the ground. Well, the said application. Well, no, the learned court of the so-and-so by an order dated 23/2023 dismissed the said application filed under section 8. On the ground. That as the lease expired on 10/8. On the ground, that the lease was for a period from 10/8/2017, was for a period of 12 years from 10/8/2012 and 11/8 to 10/8/2007 and 11/8/2007. The lease expired on 10/8/2019 and 11/8/2019. The learned trial court further opined that there was nothing on record to show that the agreement for lease was renewed. First, the suit having been instituted after the period of the expiry of the lease agreement for eviction of the tenant and for mean profit, and there was no valid lease deed agreement, the civil court had the jurisdiction to decide the dispute. And accordingly, the said application under section 8 was dismissed. Being agreed, the petitioners herein preferred an appeal under section 37, 1 small a of the Act of 1996 before the Court of the Civil Judge, Lakhimpur at North Lakhimpur. First, the learned Court of the Civil Judge, Senior Division, Lakhimpur, hereinafter referred to as agote question again, First Appellate Court, hereinafter referred to as the learned First Appellate Court, by an order dated 6/1/2024, dismissed the said appeal. The learned First Appellate Court opined that for referring the parties to arbitration under Section 8 of the Act of 1996, the standard of scrutiny to examine the non-arbitrability of a claim by the referral court is only prima facie. It was observed that the referral court has to confine to only a prima facie first review, and the court has to prima facie find that a valid arbitration agreement exists. Where's page 7?
Your Lordship, that I brought by record of my speaking.
Thank goodness.
That page went missing my
That I pointed out, that was missing, and by order of the court, they have brought on record, my lord.
filing.
Additional affidavit, my lord, at page 302, 302, 303, my lord.
The Learned Trial Court, First Appellate Court, further, upon taking note of the agreement dated 10/8/2007 and 11/8/2007, opined that the term of the lease and license was for a period of 12 years, thereby expiring on 10/8/2019 and 11/8/2019. And thereafter there appears no renewed agreement on record, and observed that the cumulative fallout of the same was that the arbitration clause in the expired terminated agreement cannot be said to be either existent or valid. Accordingly, the Learned First Appellate Court affirmed the said order. It is under such circumstances the present proceedings have been filed by invoking the supervisory jurisdiction under Article 2 to 7 of the Constitution. This court have duly heard the learned counsels appearing on behalf of the petitioner as well as the respondents at length, and have also perused the materials on record. This court finds it very apt at this stage to observe that the Arbitration and Conciliation Act 1996, that the Act of 1996 is a self-contained code in itself. The jurisdiction under Article 2 to 7 of the Constitution in matters arising from appeals, after appeals under Section 37 of the Act of 1996 is far more limited. And it is only when such orders and judgments are passed which shocks the confidence of this court, the conscience of this court, exercise of jurisdiction, supervisory jurisdiction would be permissible. In the backdrop of the above, let this court now take note of the dispute and as to whether this court is required to exercise the supervisory jurisdiction. This court, upon perusal of the materials on record, finds no good reason to exercise its supervisory jurisdiction for the following reasons. First, the agreement on the basis of the agreements on the basis of which the petitioners herein rely upon are agreements for the year, are agreements of lease for a period beyond 1 year. Full stop. Neither the agreements are stamped in terms with as required under law, nor the agreements are registered. Considering the above, the said agreements cannot be taken into consideration for the purpose of looking into the contents as regards the existence of an arbitration agreement. On this ground alone, the instant application is required to be dismissed. Number two, this court further finds it relevant that these agreements were, no, secondly, this court have duly perused the orders being passed by both the courts below. And in the opinion of this court, the orders do not, the orders so passed are not which would shock the conscience of this court. More particularly, when there is no error in exercise of jurisdiction. Considering the above, the instant course, this court finds, no, thirdly, the dispute in question squarely falls within the purview of the Assam Urban Area, falls within the purview of the Act of 1972, which is a rent control legislation. Full stop. Taking into account the judgment of the Supreme Court in the case of Booz Allen versus full name Booz Allen versus
Booz Allen and Hamilton, madam.
and Hamilton versus
That I have to give, madam. Reference I have 2011 5
versus
SBI Home Finance.
Yes, SBI. madam.
so and so reported in
2011 5 SCC.
so and so. The dispute in question is not arbitrable. First, accordingly, this court finds no ground for interference for which the instant petition stands dismissed with cost quantified at 25,000. Full stop. This court further, the interim order so passed by this court is interfered with, is vacated, and the parties who are duly represented before this court are directed to appear before the learned trial court on 26th of May 2025 for further proceedings of the suit. 35. Make it 35. These type of matters, cost is to be given. It is absolutely.
That's a terminable thing that law.
One thing very important is this type of cost, I should make it 75, which will now ask you to go to Supreme Court. Let us file as SLP. Good. 25 is to given. Argue. Where is the entire copy of the judgment? Page 60. Okay. So after no. After read 72. The last line. Then what is there thereafter? Huh? Then? No, thereafter. So where is that page?
Page 67. Page 67.
Page?
67.
No. Page 67 is dismissal of the appeal. I'm not on there. Where is that page? After that? In Mizze case number 119/2018. 72A, I don't have any 72A out here. Neither the certified copy has it. The certified copy only has till that. You have a copy of that order? Give it to me.
72A page. 72A page.
I don't have. You give it to me. I'm not going to hear you. You give it to me. Huh? Happened? Did you file any case against that lawyer? Sir? No? Where? What have you explained? What delay? How? How is it possible? You have participated in the trial. Then how is it possible? So, have you done any, taken any action against the council? No, then. Absolutely. 2016, the judgment was pronounced in open court. Then you participated even in the arguments. So have you taken any action against the council? Then matter over. You cannot. This is absolutely a false statement. No. The explanation is not so good. Where is your application? What is this? It's not mentioned which is the name of the council. No, there's no mention here. No, there's nothing mentioned. This is absolutely false. Chalo, let's dismiss your case. Heard, Mr. Heard, Mr. Your name? F.A. Hassan. What is your name? R. R. Mojumdar, the learned counsel appearing on behalf of the appellant. Mr.
Correspondence and
Mr. N. Hawk, who appears on behalf of the respondents. This is an appeal filed under section 100 of the Code of Civil Procedure of 1908, for short the code, whereby the order dated 6/5/2019 passed by the learned civil judge Borpeta, for short the learned First Appellate Court, entitled Appeal number 38/2018. In Mize case number 119/2018, arising out of title appeal number 38/2018, was dismissed. Thereby confirming the judgment and decree dated 22/6/2016, passed in title suit number 141/2013, passed by the learned Court of the Munsif number 1, Borpeta, for short the learned trial court. The instant appeal is being taken up at the stage of order 41 rule 11, as to ascertain whether there is any substantial question of law involved in the instant appeal. Full stop. It is taken note of that by way of an additional affidavit, the learned counsel, the appellant have urged three substantial questions of law, have urged proposed questions of law as substantial questions of law which arises in the appeal that can be formulated, which are, for the sake of convenience, are reproduced herein under ABC. First, at the outset, it is relevant to take note of that the questions of law so formulated, so proposed at serial number A and C being totally vague and being totally vague, comma, the same cannot be formulated as cannot be said to be a substantial question of law which arises in the instant appeal that can be formulated under section 104 of the code. Insofar as B, question of law B, bracket B, is concerned, let this court duly take note of as to whether the learned first appellate court was justified in dismissing the appeal on the ground that the cause shown was not a sufficient cause. Full stop. This court, during the course of the hearing, was provided an application, the application filed under Order 41 Rule 3A, read with Section 5 of Order 41 Rule 3A, read with Section 151 of the Code and Section 5 of the Limitation Act, which was the application seeking condonation of delay. It was mentioned in the said application that the petitioners, that the appellants herein were illiterate and after receiving the summons from the court of the Munsif number 1 Borpeta, the appellants appeared before the court and engaged a counsel by the name of Abdul Mateen Ahmed by executing a wakalatnama. It was further mentioned that the appellants had put their signature as and where dictated by the learned counsel and thereby submitted their written statement. It is also mentioned that the appellants have met their counsels regularly and the counsel informed the appellant that everything from their end were properly done and there was nothing to be worried. However, in the first part of the month of July 2018, the appellants met the counsel and asked him about the case. But in reply, he demanded an amount of rupees 2,000 from the petitioner, from the appellants. Finding no other alternative, the appellants returned home to accumulate rupees 2,000 for the advocate. On 26/7/2018, the appellants met their counsel and paid rupees 2,000 to him. And the appellant and the counsel informed him, asked them to obtain a certified copy of the judgment and decree. Immediately thereupon, the appellants applied for the certified copy of the judgment and decree of title suit number 141/2013, which they received on 30/7/2018. On receiving the said certified copy of the judgment and decree, the appellants went through the case record and came to know that the plaintiff's suit was decreed on 30/6/2016. Thereupon, the appellants again engaged the same counsel for filing the appeal and stated that they had paid him rupees 6,000. However, the counsel on 12/11/2018 returned the brief to the appellants and stated that there was no ground to prefer an appeal, and as such, he did not draft the appeal. Under such circumstances, the appellant, through the engaged another set of lawyers who preferred the appeal on 1/12/2018. Full stop. Is this on affidavit or verification? It is also relevant to take note of that the said application so filed under section 5, read with order 41 rule 3A, 5 of the Act of 1963, read with order 41 rule 3A of the code, was not on the basis of an affidavit. Be it as it may, the respondent herein filed objections to the said application, and the learned trial court, first appellate court, after taking into account the various material, taking into account the material, taking into account the facts, taking into account the application so filed, as well as the objections so received, came to a categorical finding of fact that there was no sufficient cause from the findings of facts so arrived at, it is seen that the suit was duly contested by the defendants, by the appellants, by filing their written statement. And I had also cross-examined the plaintiff witnesses. But however, the defendants, appellants did not file their evidence in spite of 3 consecutive adjournments. It is also seen that on behalf of the defendant, the counsel had duly, on behalf of the appellants, the counsel had duly addressed arguments. And thereupon, the judgment and decree was passed on 30/6/2016. Full stop. These findings of facts so arrived at
by the learned trial court, by the learned first appellate court. This court had duly perused the materials on record and nothing could be shown that the findings of facts were arrived at by the learned trial court, by the learned first appellate court. They are perverse. Considering the above, comma, the substantial question, the question of law so proposed at serial number B, in the opinion of this court, cannot be formulated as a question of law in the instant proceedings for which the instant appeal stands dismissed. Take on wait, huh? That her, what is your substantial question of law? Absolutely, these are not substantial questions of law. 1 to 4 are nothing to do. First of all, tell me, you are the defendant. You are the defendant. What right do you have over the land? Understood. He has shown the deeds of sale. No, they were exhibited sale deeds. No, these are not substantial. You have no case. Hello. Another second appeal goes for a 6. No case. Khotian? Did you prove the Khotian? No, did you produce the Khotian? Then? Here. First of all, I will get the jurisdiction first. I will not take up that. Why didn't you do it before the first appellate court? No. Yeah, no, that is not the question. Have you mentioned anywhere that you had a Khotian? No, Mr. Where is your Khotian in your written statement? Mr. Where is,
From page 53, madam.
Mr. Dhar, in your written statement, where is your Khotian?
Have you mentioned anything in your plain written statement?
Not mentioned, my lord.
Huh?
Not mentioned.
Yeah. Written statement objection filed by EA. Is this a page 50 is the written statement?
Page 53 to page 55, my lord.
Huh?
They have given a good printed copy, my lord, which begins from page 50. It's a good
This is the written statement.
This is the written statement, 3 pages long, my lord.
You say that your entire case is that you have entered into some agreement. Page paragraph 9. What is all these things? Page? I'm not going to look into application without there being anything. Hello. Supreme Court under 142 can help you. Nobody else. I can't. Lekho, heard Mr. N. Dhar, the learned counsel appearing on behalf. No case, Mr. Dhar. Mr. Dhar, you want a long judgment, I'll pass a long judgment now in your favor. That is the satisfaction you can get, nothing more than that. Where you give it to me? Where is the final Khatian? Where have you mentioned in your written statement? You best one thing, you go there, you have a Khatian, apply under 25. Go. Lekho, heard Mr. Mr. Endor, I only am thankful for you that to reduce the 5 questions to 2 to make the judgment shorter now. That is it. Nothing more than that. No, Mr. Dhar, no. Chalo. Salary is enough. Salary is enough. Enough is the salary. Heard Mr. N. Dhar, the learned counsel appearing on behalf of the Mr.
H.K. Borua, my lord.
H.K. Borua appearing on behalf of the respondent. This is an appeal filed under section 100 of the Code of Civil Procedure challenging the judgment and decree dated 26/6/2024 passed in title appeal number 02/2002 by the Court of the Learned District Judge Karimganj. Isn't it?
2022.
Isn't that? Karimganj?
Karimganj, my lord. Karimganj, my lord.
Yeah, by the Learned District Judge Karimganj, whereby the appeal was dismissed. District Judge Karimganj first appellate court, whereby the appeal was dismissed, thereby affirming the judgment and decree dated
9/5/2018.
9/5/2018, passed by the Learned Court of the Civil Judge Karimganj in title suit number 50/2013, whereby the suit was decreed in favor of the plaintiffs. Full stop. The instant appeal is being taken up at the stage of Order 41, Rule 11 of the Code to ascertain as to whether any substantial question of law can be formulated in the instant appeal. Full stop. Mr. N. Dhar, the learned counsel appearing on behalf of the appellant, have proposed, submitted that though in the memo of appeal, various questions have been proposed, but he would rely upon the, he would propose only the following 2 questions of law to be substantial questions of law involved in the instant appeal. Egehonde. The question which arises before this court as to whether these two substantial questions of law, if these questions of law can be at all formulated as substantial questions of law arising in the instant appeal. For the purpose of asserting the same, this court finds it relevant to take note of the facts which led to the filing of the instant appeal. For the sake of convenience, the parties herein are referred to in the same status as they were before the learned trial court. Read the plaint. The respondent herein is plaintiff. Well, one now.
One plaintiff.
Respondent is alive.
Is alive, my lord.
Okay, at last he may get the suit land. The respondent herein as plaintiff had instituted a suit being title suit number 50/2013 before the court of the learned court of the civil judge Karimganj, hereinafter referred to as the learned trial court. The case of the plaintiff in the said suit is that one Sudhir Kumar Dev was the original owner of the suit land and property who sold the same in favor of one Niruda Sundari Goswami by the registered sale deed number 7020/7030 dated 28/4/1966, and further in favor of Navagopal Goswami by sale deed number 206 dated 12/1/1973. The said Niruda Sundari Goswami expired, leaving behind one son, namely Navagopal Goswami, who became the absolute owner of the suit land and property. The plaintiff, Navagopal Goswami, also passed away, leaving behind 4 daughters, namely number 1, Jharna Goswami, number 2, Gita Goswami, number 3, Meeta Goswami, and number 4, Swapna Goswami, as his legal heirs and successors. On the basis of an amicable arrangement amongst the 4 daughters of late Navagopal Goswami, the eastern part of plot 1 of the suit land, at measuring 0.08 acres, and the entire plot of plot 2 of the suit land fell in the share of Jharna Goswami, Gita Goswami, and Mitu Goswami, and the rest part area of plot number 1 of the suit land, measuring 0.03 acres, fell in the exclusive share of Swapna Goswami. In course of time, the said Jharna Goswami, Gita Goswami, and Mitu Goswami sold their part of the share by the registered sale deed number 3066 dated 25/8/2008 in favor of Abdul Malik Chaudhary, and the said Abdul Malik Chaudhary sold the same in favor of Abdul Azim and Jamaluddin. The plaintiff, Swapna Goswami also sold her share of the suit land in favor of Salma Begum by the registered sale deed number 4689 dated 19/9/2011, and in that way, Abdul Azim, Jamaluddin, and Salma Begum became the owner of the entire suit land and property in place of Navagopal Goswami as his legal heirs. The said Abdul Azim, Jamaluddin, and Salma Begum resold the suit land and the property in favor of the petitioner, the plaintiff, by the sale deed number 340 dated 6/2013, and accordingly the plaintiff became the absolute owner, having right, title, and interest and possession over the same. The plaintiff's further case is that on account of his business, he used to reside at Dimapur, Nagaland, And after a few months of the purchase of the suit land, the defendants requested him to allow them to reside as a licensee over the same. And considering the plight of the defendants, the plaintiff allowed them to reside in the suit land and property as licensee with a condition that the defendant should not part with the possession of any portion of the suit property with anybody or change the nature and feature of the suit property, and as well as to vacate the possession of the on demand being made. It is the further case of the plaintiff that on 31/10/2013, when he visited the suit property, he found that the defendant illegally constructed two numbers of kacha houses over the suit property without his knowledge and in violation of the terms and conditions for which they were allowed to live as licensee. Pusto. The plaintiff requested the defendants on the very day to vacate the suit property, expressing his need for construction of a residential house, but the defendant not only refused to vacate the suit property, but also attempted, threatened and broadcasted the same, but refused to vacate the suit property, but also threatened the plaintiff that they would change the nature and feature of the suit property. It is under such circumstances the suit was filed seeking right title and interest over the suit land as described in Schedule 1 to the plain for recovery of khas possession of the suit land as described in the first schedule to the plain and the house described at serial number 1 of the second schedule mentioned in the plain by evicting the defendants therefrom, and the defendants be directed to hand over the peaceful vacant possession of the suit's first schedule land and the house described in serial number 1 of the second schedule by demolishing the houses described at serial number 2 and 3 of the second schedule in favor of the plaintiff within the time as may be specified by the court, semicolon, for a decree for recovery compensation from the defendant at the rate of ₹400 only per day from the date of institution of the suit till the plaintiff gets vacant possession of the suit land for permanent injunction, etc. The defendant jointly filed their written statement come written objection, isn't it? Written statement come written objection or what? Yes. Pusto. In the said written statement come written objection, the facts of the case were denied. The averments made in the plaint were denied. It was stated that the defendants were licensees under Srimati Jharna Goswami and not the plaintiff. Pusto. It was also mentioned that the defendants were residing in the houses which were constructed by the defendants since long back with due permission of Srimati Jharna Goswami. Further to that, the defendants also stated that Srimati Jharna Goswami had agreed to sell the suit land to the opposite party, to the defendants, and entered into a sale agreement, and Srimati Jharna Goswami also obtained ₹20,000 as advance from the defendant number 1 out of the total value of the land at ₹80,000. But subsequently, Srimati Jharna Goswami did not agree to sell her portion, and Srimati Jharna also did not raise any objection for residing over her land. And till today, as a licensee, the defendants are residing her land, and till date, and the defendants were therefore residing over the said land as licenses under Srimati Jonna Goswami. On the basis of the pleadings, the learned trial court framed as many as 4 issues, which being relevant are reproduced herein under 1 to 4. Full stop. Issue number 3, on behalf of the plaintiff, 4 witnesses were examined. Witnesses were examined and various documents were exhibited. It is very pertinent to mention the document, the exhibits, the documents which were exhibited included Exhibit 2, sale deed number 3066 dated 25/8/2008. Exhibit 3, power of attorney number 65 Roman 4 dated 24/2005. Exhibit 4, sale deed number 25 dated 5/1/2009. Exhibit 5, sale deed number 2938 dated 29/2011. Exhibit 6, sale deed number 340 dated 6/2/2013. And Exhibit 7 and 7-1 were revenue paying receipts. On behalf of the defendant alone, on behalf of the defendant, 1 witness adduced evidence and he exhibited certain tax receipts as Exhibit A and B and certified copy of the electoral roll being Exhibit C to E. Full stop. The learned trial court amongst the 4 issues which were framed, the issue number 3 is of relevance, which pertains to as to whether plaintiff had right title interest over the first scheduled land and multi-right over the second scheduled land. Full stop. The learned trial court, by the learned trial court, after duly taking note of the evidence on record, came to a categorical finding that the plaintiff had absolute right title and interest over the suit property described in the schedule to the plaintiff, and the defendant had no right to retain the possession of the suit property. Full stop. On the basis of the said issue number 3, the all other issues were decided. Thereby, the suit was decreed as per the relief so claimed in the plaint. Being agreed, the defendants preferred an appeal before the court of the learned district judge, Karimganj, which was registered and numbered as title appeal number 02/2022. The learned first appellate court dismissed the said appeal by dismissing it and thereby affirming the judgment and decree passed by the learned first appellate court, the learned trial court. It is under such circumstances the present appeal has been filed. In the backdrop of this above, let this court take note of as to whether the substantial questions of law so proposed can be at all be formulated as substantial questions of law involved in the instant appeal. Full stop. The first question proposed is as to whether the impugned judgment and decree passed by the impugned judgments as to whether the impugned judgment and decree passed by the learned courts below in decreeing the suit of the plaintiff and thereby declaring the title of the plaintiff over the entire suit land ignoring the pleadings in the plaint and solely basing basis on Exhibit 6, executed in favor of the plaintiff, ignoring the final khatiyan of the suitland, and that too without impleading the actual owners and co-sharers of the suitland, have resulted in perversity and miscarriage of justice. Full stop. This court finds it very pertinent to mention that a perusal of the written statement so filed by the defendants do not mention anything as regards any khatiyan being issued in favor of the defendants. The written statement is completely silent as regards who are the actual owners, or there was the written statement. Now, the written statement is completely silent as to who were the co-owners of the suitland, and that the suit is bad for non-joinder of necessary party. Full stop. This court further finds it relevant to take note of. This court further takes note of that. Full stop. In the instant case, full stop. This court, in the instant case, by virtue of order, the provisions of Order 1, Rule 13, the defendants having not raised the issue as regards non-joinder of any parties, the defendants, oblique the appellants, herein are stopped by law from raising such an issue. Full stop. As regards the question pertaining to issuance of ignorance, as regards the question that the learned courts below have ignored the final khatiyan, it is relevant to take note of that there is nothing mentioned in the written statement as regards issuance of a final khatiyan in favor of the appellants, or as well as there is also no mention, as well as there is no evidence led in that regard. Full stop. It is a subtle principle of law that to be a substantial question of law, the same has to have roots in the pleadings, the issues so framed, as well as the findings of the courts below. Full stop. As nothing is mentioned as regards the final khatiyan, the same cannot be made apart, be formulated as a substantial question of law. Full stop. This court further takes note of that both the courts below have, on the basis of appreciation of the evidence, have categorically held that the plaintiff has the right, title, and interest over the suit land. Full stop. The said sale deed, which have been on the basis of which the plaintiff claims right, title, and interest, have also not been challenged by the defendants. So consequently, the question of law so proposed under no circumstances can be said to be a substantial question of law which can be formulated. Number two. The second question of law which have been proposed is as to whether the impugned judgment, order and decree passed by the learned courts below are otherwise bad in law, and as such, these are liable to be set aside and quashed. Full stop. This court, the said substantial question, the question of law so proposed, reminds this court of Reminds the court of the judgment of the Supreme Court in the case of so and so by the citation did it. Wherein the Supreme Court had observed that such questions of law should not be framed as substantial questions of law. First, considering the above, this court finds no merit in the instant appeal for which the instant appeal stands dismissed. In the peculiar facts of the case, this court is not inclined to impose force. Hey, itu kuntu judgment na order 41 না এটা পাইছি কোথায় বলো রিসেন্টলি আপনাকে রিসেন্টলি
Item 14.
yes bad case Please. We do one thing. Mr. Bhagavati, we'll take up this thing on some other day. Okay? Today, 2 RSA is enough for the day. Needn't be scared of that. This code is bad, really bad in order 41 or 11. But anyways, we'll have it on some other day. Today, we are already happy. When do you want it? Try not to have it on a Monday when I go through the break. Let us have it on 2nd of June. 2nd of June.
For orders. Item 15.
No steps. Why no steps have been taken? Huh? Please note indicates AD card in respect of service upon respondent number 2 will have been received of, but neither AD cards nor answer. So are you going to take steps or not? Ms. So appearing on behalf of the appellant submits that 7 days time may be granted to take steps. So taking into account the above steps be taken upon the respondent numbers, fresh steps be taken upon the respondent number 1, 3, 4, and 12 by way of registered as well as usual within 7 days from today. Who's a failure to do so, the matter be again listed before this court. And this court, in such circumstances, would be constrained to pass appropriate orders.
Sixteen.
Who is respondent number 2? Respondent number 2 is who?
Owner of the vehicle, your lordship. The two vehicles involved, owner of one of the vehicle, owner of the bus.
What is the direction given? You are the claimant. You are the claimant. What are you asking for? Huh? Who? Why is it required? Father was who are you? Appellants means? How are you maintaining this? How is she maintaining this claim?
Yes, your lordship, the deceased, she was the owner of the vehicle
Ah, then
and now she has expired.
it will be on the basis of the personal accident cover. How is it possible you are maintaining this type of appeals? Hello, we dismiss it on which date? Calculate a good lucky day. Let's dismiss it on. Hearing? What hearing? Hearing? What hearing? These matters do not require hearing, isn't it?
Okay.
Then she also says, not hearing it. Okay, when do we dismiss it? Okay, let us dismiss it on 27th of May at 2 p.m. Chalo, we dismiss it right away. No, we dismiss it right away. Not necessary. You have no business of filing this claim petition because of a mother. Mother was the owner of the vehicle. Then, where's the question of filing claim? Goodness, let us dismiss it right away. You are lucky somebody has admitted this type of matters. You are not dismissed. I'm not challenging it.
Your lordship, we have given an opinion to our company to file a cross appeal, but they have not responded it back, so.
Then why are you not withdrawing this matter? In the result, the claim petition is allowed and total amount of rupees so and so, so computed on behalf of the heads of rupees so and so, have to pay the compensation amount of rupees so and so to the claimant in the ratio of 50:50. Atul Chandra Sharma, Devraj Sharma, Devashish Sharma, Atul Chandra Sharma. Branch manager. Atul Sharma, 4. Accident, what accident will happen? Vehicle belong to whom? He has to pay means branch manager, national insurance. Who is
Your
national
lordship,
insurance?
two vehicles involved. There's a bus and a Tata Safari. The mother who is now deceased, she was traveling in Tata Safari and it was driven by her husband. So that is Tata Safari, and National Insurance Company is the insurance company for the bus. So the two vehicles involved.
Okay.
And so in the judgment, the tribunal awarded 50:50 ratio upon the insurance company for the bus and the driver of the Tata Safari.
Now, why have you filed this appeal? Huh? You have deposited some amount. You paid your amount, no?
No.
So what do you want now? You want to implead yourself on behalf of the respondent defendant number 4. So what do you want to do? The counsel appearing on behalf of the,
Sure, but the driver, that is the deceased, was made to pay 50% of the amount in the tribunal, and now who will pay that 50% which he was supposed to pay?
don't worry, this won't go. Don't show me that. This won't go. You go to the Supreme Court may give you. I'm not going to give you a single penny here. This is a case of this. Where is the question of third party? It has been informed that Mr. So-and-so, who appears on behalf of the appellants, submits that the respondent number 4, who is the father of the appellants, had expired. Gustav. Taking into account that the respondent number 4, the legal representatives of the respondent number 4 would be the appellants only, comma, the name of the respondent number 4, comma, this court duly takes note of the said and the appeal shall proceed accordingly. This is the matter for hearing in the usual course. In the meantime, you file or file a cross objection. I'll give you time. Yes.
17.
Service complete. Service complete.
No, my lord, my client has expired and accordingly I had filed a petition under order 22 rule 10A. Now giving the name, they have already impleaded. But
313233.
Yes,
They have already filed there. Who is appearing for that?
my lord, no notice is served upon them.
No. Learned counsel advocate has appearance on behalf of respondent number 313233 by filing wakalattam. Maybe you may not have been informed. এইটো হয় না চাই লওঁ এইটো কি আছে The office note
My lord.
dated
Huh?
8/1/2024 shows that the respondent newly substituted respondent number 313233 is duly represented by filing wakalatnama. Gustav. The LCR has also been received. List the matter for hearing in the usual course, liberty given to both the parties to file application for early hearing.
18. Item 18.
I am appearing for the respondent number 4, 8, 20 and 22, madam.
I'm appearing for 49, 50, 51.
Huh?
49, 50, 51.
Service is complete.
Not complete, my lord. The appellants are to file, my lord, justice service affidavit, my lord. They are not filing, my lord. Taking time, my lord. There is interim
None
order.
appears on behalf of the appellant or the petitioner on call. Mr. So-and-so appears on behalf of the respondent numbers
I'm for 4, 8, 20 and 22.
22. Mr. K. Vachaji appears on behalf of the respondent number 49, 50 and 51. Full stop. Taking into account that the service is not complete, comma, a further chance is given for the petitioner to take steps by fresh steps upon the other respondents who have not been affected service. Meaning thereby the other respondents who are not represented before this court today. Full stop. Steps be taken by way of registered as well as usual within 7 days. Full stop. It is also taken note of that the interim order passed on 28/6/2022 have not been extended after 22/4/2024. Full stop. The learned trial court therefore can proceed with title suit number 217/2009 pending before the in accordance with law. Full stop. The registry shall duly intimate this order before to the learned trial court.
19,
Service is complete. Service complete. LCR received, leaves the matter for hearing in the usual course, liberty given to both the parties to file application for early hearing.
One submission, Lordship. Till now, they have not deposited the 50% average amount. And for respond number 1, Lordship.
Is there a stay?
No stay, Lordship.
Is there a stay?
There is no stay, Lordship.
Then why you will deposit? Go fight out. Tribunal. You know if there is no stay. Next.
20,
What is this? Why the LCR has been called? Huh? No, why the LCR has to be called? Okay, so you are appearing for the respondent?
My lordship, I'm appearing on the behalf of this one.
You are appearing for the respondent? Okay. The petitioner and the respondents are duly represented. Full stop. The records. Goodness. Scan copy or the original record ID, no? Full stop. The records, the scan copy of the LCR has also been received. Full stop. List the matter for admission on 28/5/2025. Full stop. Interim order passed earlier shall continue till the next date.
21,
Where do you want to go? From? Nearby. 30 kilometers. Huh? You?
Well, I'm from, I'm also not in the proper town of the Karimganj. I'm in between, my lord, Badarpur, that is Gharmora, then Hailakandi, it is a Hailakandi district.
Which is nearer to you?
Near to be the Hailakandi, yeah, Karimganj.
Transfer. You file your written statement. On. You want to file, you want the transfer, I'm allowing it. Then transfer. You file your written statement on 16th of June before the trial court. Allow for you, huh?
22.
Stay order is there.
Okay, we get it. I'm directing her to file an appeal and file her written statement on 16th of June before the learned trial. Appear before the principal judge, Hailakandi district judge,
22.
Uh, Notice could not be served as addressee could not be traced. NCR is there.
I for response number 1.
Who is response number 7? You are the? What is the ground of challenge? Huh? You've got the money?
No, no.
Stay. Stay is granted. Payment of 50%. Have you deposited? Okay. The counsel appearing on behalf of the appellant, Mr. S.K. Goswami, shall ascertain as to whether whether the deposit of 50% have been made pursuant to the order of passed in IE number 1215, isn't it? Of 2023. Full stop. List the matter again on 30th of May 2025. We'll see.
23.
Survey is complete. 23. पूरा निकले वो दिख जाए. Huh? None appears for the parties as borrowing interim order shall continue further proceedings of CR state. What are you challenging? On the ground that the suit is barred under order 21 rule 101. What about the service? Who is the plaintiff? Huh? Server. Dusty service. Dusty service. Full stop. It is seen that the service upon the respondent number 1 is not complete. Full stop. This court also duly takes note of that the further proceedings of title suit number 677/2022 pending before the court of which court? Civil Judge Junior Division number 1 at Kamrup at Guwahati have been stayed. Full stop. Accordingly, this court directs the petitioner to take steps upon the respondent by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. This the matter again on 28/5. Aji ki day? Yeah, no. Today is 13, no? 14. List the matter again on 4th of June 2025. The interim order passed earlier shall continue till then.
24.
Service complete, Mr. Bhagavati? Huh? Service complete. It's okay, service is complete. We'll have it for admission. The service being complete, is there a stay?
No, stay.
Huh? No stay.
No stay.
You want to stay? Okay.
This is.
Yes, sir. Service being complete, list this matter again for admission on 23rd of May 2025. We finish it off on that date.
25,
Service is not complete. Service is not complete. Hmm? Neither ID card nor service has been returned. Process server has been received wherein it is stated notice upon the respondent was received by the wife of the respondent. Okay. So service is complete. Okay. You filed an application on the what? Okay. Taking into account the office note dated 19 to 2025, the service is complete insofar as the respondent is concerned. Accordingly, list the matter for admission on 30th of May 2025. Interim order passed earlier shall continue till then.
26,
Neither ID card nor service not complete. Service is not complete. Service being not complete is the matter of the completion of service. I have no interim order. You have not affected the service, so how can I extend the interim order? So what? I can't help it. Respond number 5 expired. You want this court to commit a crime against a dead person? It will be a crime. I don't know. Huh? The respond number 5 had expired. What to do? I'm not going to do that. Process server, yeah, have appeared on behalf of 1 and 6 to 15 in filing. Process server has not been here. Process server report has been received in demand stating that the notice could not be served upon the expired. Very good. And who is respond number 5? And who is the other respondents? Son? Brothers can't help it. Chalo. Mr. G. Bhardwaj, appearing on behalf of the petitioner, submits that taking into account the office note dated 5/5/2025, you take steps as regards take steps in view of the death of the respondent number 5, who established the matter after 2 months. No idea.
28,
How can I fix a date? So how do I fix a date? You want that this court to pass a date against a dead person? Fix the matter on 18th of June 2025. Interim order passed earlier shall continue till then. It is, however, made clear, Mr. G. Bhardwaj submits that in between, he would ensure that the due applications are filed. Yes, what is this?
28,
LCR received? What is this matter about?
There we have there are only two parties, both are state parties, I'm appearing. The court below has found out in the page.
Wait,
32.
we'll have it for admission. You can make your argument. When will you be free to argue?
My lord,
When? Is
if I
the
just
matter on,
tell the- what the reason
let
is,
us have it
just
on,
become infructuous.
Mr. Counsel, let us have it on a
Next week,
day
but any day, convenient to my lord, next week.
next to next week. List the matter on 20th of May for admission. Okay,
29,
service is complete? Service is complete. Okay, service being complete leaves the matter for admission on 4th of June 2025.
30,
Yes, now tell me what are the matters where interim orders are to be extended? Okay, service is complete. Leaves the matter for admission on 6th of June 2025. Yes, any matters where interim orders are to be extended? Huh? Okay, interim order shall continue till then. Salu, huh? Yes. You see, all the other matters where interim orders are required to be extended, kindly inform him, he will do it. And if you want a date, they will give a particular date when you want. Okay? Chalo.